Peace, 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 family. Um, y'all saw the title. Hold on a second. Let me get a couple things done here. Uh, I couldn't wait until 12 o'clock. This was supposed to come up at 12, um, but I had to get on in here. Okay. So, welcome to Navi Study Hall. Got something I want to go over with you guys. Um, those that come through here, we're still looking at the 1776 project versus the 1619, or should I just say basically the out of Africa story versus the Aboriginal story, American Indian story. And I stand alone. Okay. When I look at this, the more I realize I got to keep standing by myself on this one. And it's cool. Okay. I don't need a moral majority or a consensus. And excuse me if I have a little bit of attitude behind some things. Don't take it personal. Okay. I was waiting for a response from somebody and I didn't get that response, but I'm not going to be hindered from what I need to do. So we're going to do it a little different way. I was going to play a piece of a video from uh, Big Aboriginal's other channel that had a discussion on there, which has inspired this installment of Navi's study hall. I haven't received a call. I know he's probably busy today doing whatever he has to do, and he may not have gotten that email. So I know if it was smoke signal, I wouldn't have a problem. I'm not too sure about that as far as playing his information. Okay. So there was a conversation that went on the other night. There was a whole lot of trolling and shit. But there was a part of the conversation where, excuse me, Darvis, Aton, I know Smoke Signal was up there, Alabama, and then eventually Epic Studies. Okay. And while I was on BAP's second channel, it was being streamed to both channels, and the majority of people were on the other channel. Um, I was in the chat being rather lonely by myself, but I still entered some stuff into the chat based on the conversation. Those parts of it that I could keep up with, that wasn't a whole bunch of, I don't know what they use, gish galloping and drifting and all that stuff, trolling, whatever. And what ended up that night, I'm just going to explain it. Y'all see the title. It's the Naturalization Act, Dred Scott, and a new take on it. I saw something that I wanted to bring to the foreground that, of course, because of what was going on the panel and I wasn't getting on that panel, um, could not be brought out and developed fully. So I want to take this moment while I can in the midst of what I'm doing to bring out what I saw, something that's out here that we have, it's in our face, but it's not being pushed or explained um, in a way other than the way that the Moors brought it out years ago, that the Dred Scott case had never been overturned. Okay. And, from times in the past, when it talked about Dred Scott, it was like basically the information is in what the judge said, um, speaking to Dred Scott. And that's what he should have studied and come back with it appropriately, relying more on the American Indian story than the out of Africa slave story. Now, this conversation hasn't been pushed too much further than that, even though we as a community of social media influencers, if you would, are speaking of, I'm sorry, I missed my thought right there. Um, it's right in that discussion of, are we African, Pan-African, or are we American and American Indian? And then in the midst of all of this, on both sides of the aisle is we're Moors and Negro. Y'all know the conversation. Um, but the conversation as far as what the judge displayed or told Scott has not been pushed too much further than the colorism story. Uh, you know, classism, racism, um, skin color, this, that, and the other. Well, as I was reading through this, listening to their conversation and reading through some books that I have, there's some other things that came out, and it dawned on me that one, I didn't have this information available because I wasn't looking to it regularly, and I think a lot of other people in the community does have not really studied this the way that they need to. Um, Many of us have relied on what others have said about it and have not challenged the narrative because it's almost like, um, I want to say pissing in the wind, but it's the majority against the minority, if you would. The minority, in as much as some of us don't have as much of a voice, which has been the problem when you talk about the official story as far as our people here and the people's story. In the people's story, we can see, I saw it once when I was looking at Canada, how there is an official story, but then when you look at the people's story, some things come into question. Like, how did we get that border? Is that border, um, real? We a lot of times what I found is that because they created that border between North America and Canada, that many of us in North America do not look at the history of Canada and are not as well versed on the things that happen in Canada, just simply because of the official narrative, the U.S. public schools, and our people don't look at it. Okay, we look at those as other people, and that it's a bygone era that we don't need to look at. But when you get close to those borders, whether you're in Minnesota, New York, Michigan, Ohio, any of those places, it's more of a blurred line. Okay, between the two, you're going to come into contact with certain things about Canada, just like Canada. People from Canada are going to come into contact with certain things about North America. But the majority of people, people like myself, don't really look at that. But there is a people story. So here, even in North America, we have a people story, and that would be who you are, where your family was, what they dealt with. And then, of course, here in North America, you have another blurred line. You have a blurred line of this is what the 13 colonies said. And the people who live in that region, even though they can be on both sides of the argument, they hold I would say, an over exaggerated, um, how you want to say this, over exaggerated type of authority because they're in the East as opposed to those who are in the Midwest. Sometimes the Midwest, using Arkansas for example, sometimes the people in the Midwest, as far as Aborigines or Aboriginals or American Indians, get overlooked and overrun for the Plains Indians, which is a little, I guess it can be seen in the debate that they just had, because I remember someone mentioning about the TPs and the Plains Indians and all of this stuff. And I'm like, so the Midwest wasn't here, even though all those people from the East, a lot of them were trying to get into the interior. We're just going to overlook this for some other people, Slavi or Plains Indians or Canadians coming down, the Salish people, any of this stuff. Okay. And so the official story gets more weight, more authority than the people's narrative to it. Because even when we talk about who we are as a people, we talk about our oral traditions. But then while sitting in our conscious community with our social media influencers, suddenly our oral tradition isn't enough. We need some paperwork, right? Okay. So this is kind of where I'm at, just trying to give y'all a little bit about where I'm at. Let me see. I see a comment in the room. Ooh, who's in here? Hello, Josephine Short. Peace to you. Okay, respect. So there was a conversation that was had, and give me a second. There was a conversation that was had on Bab's channel, his backup channel, King of YouTube. And Darvis Blaylock was running roughshod. And this overabundance of this religious narrative, y'all know I still need to look at comparative religions. I still need to look at that to see some of the beginning points and merging and adaptations and all of that stuff. But for the layperson who was just raised in a Christian family, or speaking for others in a Muslim family, or non-traditional, or Catholic, or whatever it is, okay, Giaz, whatever, okay, Hebrew Israelite, all that stuff, you know, our stories are a little different. We don't look at all of it unless we actually specialize our instruction in a particular area. So when it comes to a person like myself who was raised Christian, I didn't look at other religions. I was told not to. And this overabundance of the religious narrative, um, I had to remember what I was trying to get out this drawer. Um, this religious narrative, it causes me pause, okay? Because in many aspects, our folks been lying for the longest, but they had help, okay? I'll just say that's a short version. So while I was listening to Blaylock on his pushing a religious thing, specifically, if I can remember correctly, specifically that, how we fall under canon law, okay? And um, his aggression in that reminded me of another brother who said, you can't get out of this stuff because whatever you do, it's it's God's law, if you would. It's this biblical text. It's these canons and um, all that stuff. But we don't really get into the study of it, in my opinion, like we should. Okay, so here's the deal. I'm gonna try to get to this. I'm having a little difficulty here, not much, but a little bit. So the conversation, like I said, Darvis was really pushing this law and God and law and Hebrew doctrine, if you would. And he was running roughshod over the panel, because a lot of people don't have discipline, the discipline necessary to listen fully to what other people are saying. And that's one of the problems, um, that others will have to correct. It ain't my job to do anything. I'm just pointing it out right now. It don't matter to me. I know how to move. But he was running roughshod over that panel. And it got very annoying. But what happened that night, I had a little bit of time as they were talking on there, and I started pulling out books. So they would talk on one subject. I pull out a book and start perusing through it. And next thing you know, the conversation switches almost immediately. And then I pull out another book. Okay. And something was mentioned, and I had to go back and find Bacon, because one of the books that I had read, titles that I had read to the audience, was about these English writers. And my stance is still the same. They created a story and a narrative, and they got more weight through newspapers, journalism, um, propaganda than the regular people did. And we just got caught up as human fodder in the midst of it, okay? Literally becoming sheep and even scapegoats to a certain extent. So in the chat, I put something about Bacon in there based on their conversation. And I'm still struggling right now, I'm still struggling as to if I want to play BAP's stream, just a piece of it, okay? But then as the conversation moved, I pulled out another book and I started looking at it, and I got curious because I didn't realize what I was looking at or what was in this book that I had. And I'm like, oh, ooh, they not ready for this. But it wasn't the time nor the place for it. Um, and I can't really tell y'all what book that is. Um, I'll just say it's a really big Bible. Okay, that's what I'll say. It's a really big Bible. Okay, um, and not the one that our grandparents or parents had sitting on their coffee table. No, not this one. Okay, but anyway, so I pulled that one out and I was looking at it and I kind of stopped listening to the conversation. Y'all helping me with my multitasking because I can listen and text and read all at the same time. I'm doing good right now. Okay, but conversation moved again, and based on the conversation, it had me ask the question in the chat because I hate for people wasting my time. It had me add in the chat, is it law or is it justice? Now, I make this mention because Alabama comes into the panel and he brings my comment to the ears of the panelists. And when he asked that question, they say both. Me, I slapped myself on the forehead. I said, y'all just not gonna commit to anything. It was a sure deal that it was law at one point, but because of the trolling, the aggression, all that stuff that Darvis was doing, now it becomes both, so that you can't distinguish between the two. And this is the thing that has happened in a lot of areas. Okay, the inability to distinguish between the two, and then also falling into this paradigm of colorism. Okay, that if it's white it's bad, if it's black it's good, but you can't get on the black folks, so-called black folks that did this stuff, black European or no, um, because you're going against your own people. But yet at the same time, it's the black Europeans that did this. Oh no, it's the white Europeans. Oh no, it's the foreigners. It's the squatchulators, using Alabama's words. It's so mixed and mingled. It's very hard to distinguish all of it. Peace to you, brother Nasir. So Alabama brings that up to the panel. This is what is inspiring this post today. Is it law or is it justice? Now, I have to explain to you right here that not only from the conversation, but because of a movie that I just watched, the question needs to be out there and distinguished. But just like this last debate that they had, and I didn't pay for a ticket, I didn't go, I just knew, I had a feeling it was going to end up the way it ended up. Um, the terms get mixed and mingled and definitions get changed and all of this, and it makes it even more difficult for us to decide. It's called information overload. You give people so much information that they can't make a decision, and this causes them to have psychological paralysis. In other words, they can't move. Okay, over information overload. So um, the movie in question, if you guys haven't seen it, I'm just getting back into watching TV and movies and shit. Um, the movie in question is called The Beekeeper. Okay, The Beekeeper is a movie with that guy who played the hitman. I think his name is Sowell, but I'm not sure. Um, that could be totally wrong. He asked a question near the end of the movie, and he was telling the FBI agent that she had to, the FBI agent who was working under the law, if you would, her FBI thing, um, but also trying to seek justice because this was all sparked by the fact that her mother was targeted by scammers and ended up losing millions of dollars and unaliving herself. And we see this online when you see channels um, where they're talking about these scammers that you know certain people online. I can't remember any of the channels. Start to go after the scammers who are pulling these scams on old people, whether they're romance scams or financial scams or any of this. We see this in real life, but they also put it in a movie. And so there's a point in the movie near the end where uh, the guy who played the hitman had asked her or tells her, you're going to have to choose between law and justice. And I can't get the exact quote, but between law and justice. And I had just watched that movie and, I'm pondering some things in there. And I put that into the chat. That's where that comment comes from, because I realized the difference between the two. Um, law would have said that he was supposed to be caught and tried, but because of what his position was, he was just there for justice. Now, what happened in light of this on the panel was that um, Darvis to me went from his it's about the law to both only to use the military to say that you still fall under the law. I mean, you're basically not sovereign. You can't get from under it, whatever the case was, because if you were in the military, you had to be under their protocols. But he made it sound like it was an inescapable law when in actuality, being under the military means that you're under military code of justice. So I think I put that into the chat. I might have deleted it because I don't see it up here. And this is a group that's set aside because they've agreed to a particular thing. And many people are like myself, never been to the military, so we don't know the intricacies of the military, if you would. I just knew they got a code of justice, okay? And they have their own legal, lawful venues to handle that. So they had this conversation online. Now, part of this conversation went from 3 hours. Let me see what my timestamp is. I think I entered the chat about 2:38. Okay, that's where my comment is about is it law or justice? I had been there for a minute. Um, I make some comments about bacon. Where did I mention bacon at? I mentioned bacon at about 3 hours and 24 minutes, and then I disappear and I show back up at about 5 hours and 10 minutes. Okay, and I put something else in the chat. That's what this post is about. The last thing that I put in the chat, which is the Naturalization Act, Dred Scott, and it's a marketplace term or something like that. So let me catch my breath for a minute. Yeah, short it is. Okay, so let me catch my breath for a minute, and um, I'm gonna bring this chat in just so we can understand what the comment is that I made, because the study hall is going to be me reading the information that I read in between those 2 hours that I was not in the chat, because I read what Alabama was trying to say about the Naturalization Act, that part of the Constitution, and the book that I'm reading from, which you see the cover of it on the thumbnail, what you don't see is who it's by. It's by Stone, Steedman, Sunstein, and Tushnet, and it's the third edition that was published by Little Brown and Company. Okay, and this is what I mean about some of us don't have that official study, if you would. Okay, um, so I started to read what they said about the Naturalization Act, and the book itself opened up the information about Dred Scott. I really didn't want to read it, but I kept reading, and I know there's a few, I want to say incomplete sentences or thoughts that are in here that kind of made it a little confusing, which is something else we have to deal with. But as I worked through it and then popped onto something else that it had revealed, this is when I come back in the chat and I mention my take on it. And it's after reading this information. So let me catch my breath. I'm gonna mute the mic for a minute. I'm gonna pull this other stream in. I may or may not play it because, when it comes to this verbal bantering, it can be really confusing. But I want y'all to see what was written in the chat. Okay. So give me a second. Okay, so you guys see what panel it was, what their topic was about, and well, this is in the middle of the night when most of y'all sleep, trying to get ready for work or, or whatever. This for us late night owls, which is really crazy for me now because I used to be working and driving at night so I could listen to a lot of this, but now I'm home and it just I fall asleep on them and wake up in the morning sometime. Um, and sometimes I'm there almost all night. But in this chat, this is the comment that I came back with after reading the information. Okay. And I know that's kind of small for you guys. If you're on your TV, you could probably read it, but most of us on our phone cannot. So you see here at 4:10, I say, "Can y'all get a room?" Okay. Yeah, I talk shit. But anyway, when I came back at 5:10:09, I say, it was about states, Southern and Northern, battling over who would control government, slave or free states. The first citizen was the states, and the aliens overall were the people of those states. This comes into play when we start talking about squatulators and you're talking about foreigners. But let's continue. Then I come back and I said, this is where the naturalization rule comes into play and the courts, Tanny, making its stance upon race utilizing Scott. And I know this is a run-on sentence here, but it says, it was a major blunder, okay, within the delicate balance of power. And that's what we need to understand. It's economics, but the whole point of the enumeration, which I do believe was mentioned on the panel, I think Alabama mentioned the word without going into the enumeration part of it. It was about who was going to control Congress, free states or slave states. And then there's Dred Scott, who goes from a slave state to Missouri, only to enter into this case. And the document or the part of the book that I was reading, it talked about this Dred Scott case basically being the spark for the Civil War. Okay. Now, we, on the other hand, start talking about the 13th Amendment or 14th Amendment, where it talks about slavery and yada yada. And we think that we're 14th Amendment citizens when people have told us, not to name those names, people have told us that the 14th Amendment was not necessary. Okay. But then we have this challenge and this battle over, were we, as melanated people, Aboriginals, American Indians, those of dark hue, if you would, since they made that distinction, if we were to be counted amongst the citizenry of the United States that was being formed, the federal government, or, you know, was it not even intended for us? And I'm reading through this information, trying to assess certain things, certain questions that I have, and it becomes abundantly clear to me, if not abundantly clear to you guys, that we were aliens as well to a newly formed government. And that, in my opinion, the first citizens, as you read here, or as I said here, the first citizens are the states. That's where the battle's coming, because in my opinion, when you look at how they talked about, um, I believe it was after the Civil War, how they talked about you having this type of dual citizenship, that we are not only citizens of our states and citizens of the federal government, that it supports the whole civil rights thing or civil war thing, where they talk about um, state rights versus federal rights and limiting the power of the federal government. But on the other side of the federal government are the states, which are divided between free and slave states. And remember from our reading before that the states, the slave states, wanted to control Congress, and that's what the battle was about. That the enumeration had to do with limiting the representation in Congress, because we're dealing with a representative government, as you well know, a republic, if you can keep it. Okay. Everybody guaranteed a republic form of government if you can keep it. Um, that the states, the slave states, would have had a larger majority had they been able to count all the people, because that would have given them more numbers in the House of Representatives. And so without that enumeration, it was speculated that they would have had like 50%, if not 51% or whatever, to control Congress, newly formed government, people trying to destroy the republic, and yada yada. Okay, and we know it's about economics. Who was going to, the 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 labor market in the South versus the labor market in the North. Okay, y'all know how that goes. Um, but after that limitation of enumeration, okay, not the 3/5 clause. That's the technical term for it, the 3/5 clause. The southern states only had 47%. So they couldn't take that majority. Okay, again, this is states' rights versus free states, or states' right, um, to institute and keep the institution of slavery, or if people would be able to be free for whatever reason. And I think that free has to do with who would be able to contract, if you would. And I'm not over there with you guys right now, so let me finish reading here. So it says, again, this is where the naturalization rule comes into play in the courts, Tanny, making its stance upon race, utilizing Scott. It was a major blunder within the delicate balance of power, okay, aka federal rights and states' rights. At 5:15, I say, Scott, and I don't know if this is where I put in my opinion, but um, it says Scott was bound to his governing state as it contracted in his state, and his AKA handler, whose residency was in a slave state. Then here's my opinion. I said, it is my opinion, as I have just read from constitutional law book, a constitutional law book, and written my understanding of that reading, that when you can contract with the federal government, you are no longer a slave. Okay, that's my opinion. Then I say, they said something, and I said the invasion of spoken, because this is where I think Alabama says something about the squatchulators and this, that, and the other. And I say, foreign invaders, yada yada, keeping on the white ain't right, and all that shit. It says the invasion spoken of in the Constitution dealt with invading the states, and at other points America. So we're talking about two things. So I say, as in the concept of foreign and domestic. Um, Something that was in the reading caused me to say this at 5:27. The territories are coming away from rule under France. That's a key point that we don't talk about often, because France did it before the English did. Okay. Even as I think it was Chief Holiday was mentioning last night, which I wanted to hear that conversation, but it moved when he was talking about Latin, and that French is a form of Latin, and that um, asking what was the Latin equivalent of Indian. And I wanted to hear that part of the conversation, but it didn't get there. It went somewhere else because of people's personal feelings and stuff. But I thought that was a key point in what was said on last night, this morning, whichever one it was, making the reference to Latin being part of the law, um, being a part of the law, you know, and sciences and all of this stuff. And um, even looking at how we bypass the French to get to English, the French language, to get to the English language, not understanding the transitions, as those languages had people attached to it in a landmass that they were attached to. Okay. Um, so foreign and domestic, and then, and what I say here, the territories as coming away from rule under France, and that of contracting or doing business with Indian tribes or nations. And then the last part of this that I wanted y'all to see was, I think that falls under the market participation doctrine. And I saw this in there in the reading that I did, but I was not able to really bring that out, and I didn't want to go back and continue to read the market participation doctrine, but it's the market participation doctrine that caused me to say that Scott was contracted under his state, um, and his handler was contracted under a slave state. He therefore being contracted under his handler, um, was the major problem, if you would, in the Dred Scott case, if you ask me, because I believe, and I could be wrong, and I'm pretty sure nobody's going to really say anything other than you're wrong and you don't know what you're talking about and you're a novice. And I hate when people say, start talking about stuff that they don't know about and they novices. Yeah, I heard you. I saw you. Um, but it's my opinion that in trying to keep this delicate balance, they were trying to keep as many people under that particular jurisdiction as possible, under their state jurisdiction, because people started to act like the states didn't even exist until after the war, but yet we say that, you know, the colony was on an estate and the estate was changed to, you know, states, and but the states didn't basically come out until later on. It's all convoluted in my opinion, and very tedious to dive into. Okay, I hope to some extent I made that a little clear. I don't know if I did or not. And Bap's gonna have to get me for this one. Hold on a second. Let me see if I can throw a little bit in the mix here. That's 5:34. When did I start making this comment? At 5:15. Okay, we're gonna play a little bit of this. Fair use, everyone. Listen for a second.
Some of them have more admixture than others. Like the UK people, for instance, those people don't have like much admixture, and you can see it comparing them to the people in Sicily or the people in Portugal or even French people. French people even look different than them. They have more of that Moorish. It's why they got the brown hair, brown eyes. Their hair is more kinky. Their features look different,
So that means
and that's
they
how a
got
lot.
a whole internal fight within themselves then.
Hold on a second. That's not the
And that's
spot.
how a lot
Just
of
through
them
definitions.
became exactly became in power because they're from prominent families that was niggas.
Let's go about right
All
here.
right, so
Let's go about right here.
White persons, specifically the free ones, because of course the enslaved couldn't own land.
This part about Epic, let me just bring this out before we play this, since I forgot about him. Little nuances that we don't pay attention to that Epic picked up on, and I just saw it today when I was trying to set this up. They make the distinction in this part of the discussion between, and I didn't listen to all the stuff when I was reading, but makes the distinction between white person and free white person, or free white person as it's mentioned in the 1700s, and then as it's mentioned in the 1800s, and how one of these terms, whichever one it was, is not mentioned in like Black's fourth edition, meaning certain things are changing as things are growing, as time is moving on. But I thought that was interesting because we lump the free white person all together, and then we argue about who was the free white person. And some people who came through the Moorish stuff will mention uh, the Finnish people, the Lapps, and certain things that were mentioned coming out of the Moorish information referencing this material, um, under free white persons, and other people will not reference those particular identities because there are two. Okay, as Epic brings out in here and realizes, I think he realized it for himself there, in here. So just to show you where that conversation is, Bap, don't be striking my channel. Okay, let's continue.
Participate in the politics and nothing like that because they're slaves. You see what I'm saying?
So the free white persons, what definition you reading that from?
No, not the phrase free white persons. The
Oh,
phrase white persons.
white persons. Oh,
The
okay.
free part
Just
is
white.
just talking about the status of the white person as
Oh, okay.
being a
Yeah.
free one. You see what I'm saying?
So that's from what is that Black's Law?
Oh, that's from Henry Campbell Black's Law Dictionary, 4th edition.
4th edition.
The definition of white persons.
All right. So in that same 4th edition, you have free white persons definition, and it's referring to the Naturalization Act as well. So they have a whole
Okay, give me a
different.
second. I'll go pull that one up. Give me a second.
Yes, sir. Please, because that's your discrepancy. Because free white persons excludes Caucasians, and it includes Slavs. And that's in the 4th. So there's got to be some discrepancy, and they don't even mention a red, black, or anything of that nature.
Where's the
So
ass Slav?
there's got to be a contradiction somewhere.
Where's
We
it
say
ever ass Slavs anywhere?
in free white persons in 4th, Black's 4th, it mentions Slavs.
Hey, I'll be back through here. Y'all hold it down. Grateful, be good, please.
All right, for sure. But it mentioned Slavs. That kind of threw it. Yeah, Slavs has always been in there. You know, I never get an opportunity to address that matter. I know it's going to be a, motherfucker going to jump at me, but if you read that definition, free white person, Slavs is in
Oh,
there. And the
yeah.
Caucasians are included.
If I may read it.
Go ahead.
All right. Free white persons. Free white persons, as referred to in Naturalization Act, as amended. Did you? I'm sorry. Can y'all hear me now? I think my
Yeah, you going in and
sound.
out. Yeah. Go ahead.
Okay. But y'all can hear me now, right?
Yeah, I got you.
All right. Free white persons referred to in Naturalization Act as amended. Act July 14th, 1870. So it's referring specifically to that Naturalization Act of 1870 as to the meaning of this phrase, not the Naturalization Act of 1790.
Okay. All right.
So that distinction has to be made and comprehended as
Got you.
as we move forward.
Got you.
All
All
right.
right. So that
Has
free white persons
hold on. Let me finish reading the rest of it. I want to just
is
leave it
not
like
white. Okay, got you. Okay, I misunderstood that then. That's
free
me.
white persons referred to in Naturalization Act as amended by Act July 14th, 1870 has meaning naturally given to it when first used in 1 Stat 103C3, meaning all persons belonging to the European races, then commonly counted as white and their descendants, including such descendants in other countries to which they have immigrated. It includes
You
all
got
it, in, it includes all European Jews, more or less intermixed with people of Celtic, Scandinavian, Teutonic, Iberian, Latin, Greek, and Slavic descent.
see
It
that's the
includes
mixture.
Yeah, go ahead. Go ahead.
Magyars, Lapps, Finns, and the Bakis and Albanians. It
Mm-hmm.
includes the mixed Latin, Celtic, Iberian, and Moorish inhabitants of Spain and Portugal. The
Mm-hmm.
mixed Greek, Latin, Phoenician, and North African inhabitants of Sicily, and the mixed Slav and Tartar inhabitants of South Russia. It does not mean Caucasian race, Aryan race, or Indo-European races, nor the mixed Indo-European, Dravidian, Semite, and Mongolian peoples who inhabited Persia.
Mm-hmm.
A Syrian of Asiatic birth and descent will not be entitled to become a naturalized citizen of the United States as being a free white person.
Now,
It's clearly trying to tell you that it's
you
not
made that
a
very clear.
pale skinned person.
Yeah, you made that
That's
very
basically what
clear.
it's saying.
Right. So if these Caucasians
Y'all see that little nuance in there? It's very hard to make these distinctions between one or the other thing when people are constantly interjecting, saying dumb shit, doing personal attacks and everything like that. In order to understand some of this stuff, you have to be able to listen attentively, and the speaker has to be able to speak without interruption for the proper understanding. I didn't even recognize that there was two different avenues of free white person based on almost 100-year difference. Okay. But it goes without saying because people were fighting for control of Congress after Congress was formed after the Revolutionary War up until the Civil War. Okay. Some people say that the hardest points of our history, if you would, or our ancestors' histories, was like 85 years. And I'm wanting to say that 85-year period was between the Revolutionary War and the Civil War. That's what I want to say. But what also comes into play after the Civil War and Reconstruction and the 1900s, Harlem Renaissance, and all of this is when they bring the Jim Crow in to do stuff that was in total violation of anything. It was no different, in my opinion, from when they talked about the Cherokee, when they said that the Cherokee didn't have to cede any more land over there in the East. And the Cherokee went to court, meaning the SCOTUS, the Supreme Court of the United States, and got a favorable decision. And then people from the colony of Georgia, the mayor or governor from the colony of Georgia, um, sent out his posse to run those people out. That's what Jim Crow is. Okay. We want to say that it's totally the United States, if you would, when there is a delicate balance that the official government has been trying to hold on to in its formative years. And we're not recognizing that because we are inundated with the we were slaves and the victimhood mentality. I mean, if you look at my description, I do mention victimhood in there because I really want us to come away from this because it's not about the colorism. Colorism was the monkey wrench that they threw in there. Okay. It people cannot deny how um the whole communism thing came into play with all of this. What do they call it? The Negro program under the African Blood Brotherhood. The communist they admit that the communists used the black folks' emotions and feelings about what was going on into the country to use them for their own agenda. We were used as human fodder, and here we are in 2025 still being used as human fodder because we can't make the distinction between the two or the three. Okay. Um, there was something. So yeah, that was a good little point right there for me. I'm trying to find these couple spots that I'm going to start off at because I know I'm getting ready to do some reading for those who can sit and read, and I really appreciate those of you who sat through that last reading when we went into the dictionary and started looking at mythology. I mean, I hope that helped a little bit. Um, So let me play this while I look for it again, but I did want to stop that and mention it, mention what we were looking at right there. So let me mute up and play that again, play the rest of this for you.
Occasions, right? So if these people, and I appreciate the clarity on that shit. So good.
Yeah,
That's
because they're saying the natural meaning of it.
right.
Even here, the free white persons, the natural meaning of it, it has its root in the Naturalization Act, the first one, for which that's why I went to white persons, because remember, free white persons wasn't until this Naturalization Act of 1870. But yet you do see free white persons in the 1791. But like I said, you have to make the distinction and knowing the timeline, knowing that free is talking about the status of the quote white person,
Yeah, I didn't even
which is,
know how I looked
Exactly.
over that
you
shit.
see what
I
I
looked
mean?
over that. Yeah, I looked
Exactly.
over that. Yeah,
Yep. That's a fact.
yeah. All right.
So
Because
that's
at
what I
that
was trying
time,
to make,
those
just
people were not
that
free.
clarity of
They weren't
distinction.
free, but they were considered of the white people because they're European.
Yeah,
But
yeah,
that doesn't
because
automatically
white
mean a white
person,
person is a pale skin. That doesn't automatically mean
right?
that.
The phrase white person is the Caucasian
European.
race,
Yeah,
which in
European.
1790, that's what it's referring to.
Yep.
The phrase white person. Just the free ones, though. So that reveals that there were also some that were enslaved.
That's what I'm saying.
Obviously, in
So
order
how
for them
does
to have to make
Caucasian?
that distinction, in order for that
Okay, so
distinction to
what
have to
happened
be
in
made,
1870 then? So if the Caucasian was supposed to be free then, and now they're not free now, it's not including them. What happened?
Well, there were going to be some that are free and be classified as Caucasian just based off of the region that they're in. But there may be intermixture that you know the reason why they're free. They have a more ancestor.
So what is these
Got
mulattoes?
yeah, a lot of them. Well, not mulattoes, like octoroons and quintroons and shit. They'll mix that
Uh,
blood out. They mix that blood out a lot with the Slavic ancestry.
so that's the paper bag thing,
Well,
the brown paper bag
yeah,
thing.
I'd say
If
so.
that's the case.
I mean, that's how they created the Arab. I've been saying that shit like tons of times. The Arab was created through heavy admixture. Even the Portuguese and the Sicilians and the Italians, a lot of them, they're all mixed. That's why they all look different. Every European don't look the same. It ain't the same. Some of them have more admixture than the others. Like the UK people, for instance, those people don't have like much admixture, and you can see it comparing them to the people in Sicily or the people in Portugal.
As you can see here, base two timelines, 1700 to 18, them introducing the paperback text and admixture and all of this. Country is setting up for slavery by um, one group over other, you know, skin color, setting up for the Jim Crow. Don't fall for the shit. Okay, we fell for it, but don't fall for it. It keeps you as a perpetual victim because you can't get rid of your skin color. Okay. Um, One of the things that Alabama had mentioned, and I didn't know where it was, so I didn't get a chance to play it. He had them look at, which sparked this conversation after "Is it law or is it justice?" Was he referenced the Constitution, um, Article One, Article One, Section 8 is what it was. Now with the trolling shit, because I thought it was like, okay, 1, 2, 3, 4, 5, 6, 7, 8 of this section, but you know, I'm not well versed on the Constitution. So I was in here like, where in the freak is this at? Because I had to pull out my We the People documents, writings of the founding fathers book, and actually find it. I thought it was in the constitutional law book, but they're more in depth over there. Okay. So, what happened on the panel was that Darvis was up there, and when Alabama mentioned Article 1, Section uh, Section 8, if you would, um, Darvis was like, Darvis or somebody up there was like, no, let's start and read the first one and this, that, and the other. And I'm like, in my mind, I said, the only reason why you want him to start at the top as opposed to going straight to, um, let me see, hold on one second. One, two, three. Section 8, Section 8, number 3, I forgot, subsection 3, okay, which doesn't have a number here. It's just the third stanza of them identifying what they can do under this section. He's like, well, read the first ones, this, that, and the other. No, let's start here. And I was like, the only reason why you want him to do that is so that you can find a place to keep him from looking at that the way that he wants to look at it. Okay. And I noticed that and I was like, this is some BS. Let me go read some stuff, okay? Because they're going to fight this tooth and nail for this information to come out. So that's where this started at, with the naturalization being brought into the conversation, and that's where I'm starting at as well. So I'm going to read it here, okay? Um, Section 8 up until the point that Alabama wanted us to get to. And I don't exactly know where Alabama is in this conversation, um, to bring this out, because I did that jump to find out what they were talking about as far as naturalization was concerned. So let me read this real quick. Some of you already know. So, Constitution, basically, Section 8 starts out like this, and we're just going to read to the part about naturalization, because Alabama continued to make emphasis on what it says regarding the rule of naturalization. So, Section 8, the Congress shall have power to lay and collect taxes, duties, imposts, and excesses or excises, to pay the debts and provide for the common defense and general welfare of the United States. But all duties, imposts, and excises shall be uniform throughout the United States. One, not numbered, but I'm just saying one. To borrow money on the credit of the United States. Two, to regulate commerce with foreign nations and among the several states and with the Indian tribes. Three, to establish an uniform rule of naturalization and uniform laws on the subject of bankruptcies throughout the United States. Okay, so Congress can do what? Establish a uniform rule of naturalization. Okay, and here comes the slave story. Okay, because we didn't need to be naturalized. Regardless of what has happened and what is said, those of us who were born here from time immemorial, if you would, as far back as we can find, the only place that they can say that we did any type of quote unquote naturalization, one tends to be this damn birth certificate conversation that they keep having, paperwork shit. And two, that somewhere in elementary school, we said the Pledge of Allegiance. Okay? Those two don't hold water. There has to be something else in here. And that something else, to me, is my opinion as it is, that when you can contract with the government, you're no longer a slave, which is what they were trying to stop people from doing back then with the newly formed government. Okay? So, um, where are we at here? I'm going to try to find this spot where I am, where I was at. I'm still trying to find it, you guys. I thought it was one place, but I jumped around this book a few times. So let's continue to play this, and then I'll be with y'all in a minute.
Or even French people. French people even look different than them. They have more of that Moorish. That's why they got the brown hair, brown eyes. Their hair is more kinky. Their features look different.
So that means they
And
got
that's
they
how a
got
lot.
a whole internal fight within themselves. Then
And that's how a lot
them
of
two
them
definitions.
became, exactly, in power. Because they're from prominent families that was niggas.
All right, so if you will, Epic, can we read
Yeah.
that white person's definition again?
Yeah, give me a second. I'll go back to it. Just give me like
Yeah, I got to hear that again because I glossed over that shit. I ain't gonna lie to kick it. I actually glossed over that shit. The white person's part of it because that's actually 1790. So now we'll figure out who these people are. So that 1870 thing is the reason why you got these type of people running for president at this time.
right, able to call themselves and white or whatever like that. But that's via um, you know, the different meaning as we just seen, but there is establishment is in the Naturalization Act of 1870.
And it was clever of them to these terms like black and white, because then we always think of, these skin tones, and it has nothing to do with skin tones. It's all classifications and codes.
Mm. But 1870, I think it had to do with skin tone at a certain point in time. If there was a lot of intermixing
No,
with these
it
people, a
all
lot of them did.
it's all been orchestrated, so it's all being created. The black and white it's non-existent. It's all shit that they created in order to take identity, and you gonna automatically think, oh shit, these white people. Nah, an African can come over here and he white. So what? Them is white people too? Nah,
Yeah, that's
no
a
such
fact.
thing. No such
I
thing.
got I got
They're
it
pale
pulled up
skinned, pink toes.
whenever y'all ready.
Yeah,
Go
all
ahead,
right.
let's do it.
Okay. As you white persons, as used in Naturalization Act March 26, 1790, as amended by Act February 18th, 1875. And let me see. Okay. As meaning members of the white or Caucasian race, as distinct from the black, red, yellow, and brown races. And there's another little part down there as a part of that definition. I'll read that. Where the applicant for United States citizenship is a quote unquote white person eligible for citizenship under statute, enumerating classes of people eligible therefore depends not upon ethnological classification of group to which he belongs, but upon whether members of such group with characteristics existing in 1790 when statute was first enacted were intended by Congress to be classified as white persons. Okay, now there's the intention right there as
All
to
right,
what it was meant.
break that down.
And statute uses the words quote unquote white persons as meaning primarily the European peoples who constituted the class from which virtually all immigration to the United States has come and who readily become assimilated into our civilization. So yeah, I think that's clear, man, as to the intention, at least speaking to that phrase as used in the Naturalization Acts of 1790 and as amended in 1875. Those two, the phrase white person in both those acts are the meaning as follow, and those intentions as to their meaning are as follows as well. And it's not contingent upon the ethnological classification,
Right.
but whether he's, yeah, okay, there you
Yeah.
go.
Yeah. All right. So when all these different these colors of law came in, and all these admixtures of these people coming, this 1870s, that's where you get the intermixing, right? The key word intermixing in the free white persons. I'm just kind of honing on the word intermixing and the free white person's definition. If it was initially Caucasian, and then now it was the intermixing of the European as it was defined in the 1790 white person, and then the Caucasian is no longer included in the definition of a free white person.
All right, I found my spot. Okay. I remember I jumped around this book. I found my spot, and that's enough of that shit. Okay. Um, but as we can see, it's a little bit about the colorism thing. Who's a free white person? Who's not a free white person? And when it comes to so-called melanated people being free, this, that, and the other, naturalized, not having the ability to be naturalized, part of the government, not part of the government, falling under the 13th, 14th Amendment, not falling under the 13th, 14th Amendment, being Indians, not taxed, all of this stuff, being here before the government existed, and all of that stuff. It Dred Scott, the case is the clearest place for us to look, okay? But this falls under equality of the um, this is where Dred Scott comes in, okay? Because some people didn't want to give you that equality because of the enumeration. So I found a chapter that I was supposed to be in that I'm going to be reading from today in this study of the Naturalization Act, Dred Scott, and a new take on it. Um, so bear with me. This is not my area of expertise, but I saw something in here that made me think that when we're talking about alienage, which is also another chapter in this big ass book, um, that we're dealing with people's ability to contract with states or the federal government. Okay. And it's my opinion, being in the state that I'm in right now, looking at different things that are going on, being able to identify certain things now that I didn't see because I wasn't on this side of the fence that I'm on right now. Um, that this is about the ability to do business and not about colorism. They wanted to keep us out of it by the reclassifications that were done, and also to keep us a perpetual victim by making us a perpetual victim on our skin color without utilizing our skin color and those things. So we become alien to it. But here's a hijack on becoming alien to it. I believe there is a foreign alien, and I believe that there's an domestic alien. And some of us, by just working every day, fast food, no career, no business, we're not contracting with the government. We're up under other shit. Other people are contracting with them. Okay. Um, I know that might not have been clear, but let's read a little bit. Okay. This is again from the Constitutional Law Book by Stone, Seidman, Sunstein, and Tushnet, third edition, published by Little, Brown, and Company. And if you have this book or can get this book, which is probably about 6 inches, 7 inches, 8 inches, somewhere around there in thickness. I'm in chapter number 5. It is the chapter on equality and the Constitution. This is where Dred Scott is mentioned. Okay. And the person who had this book, the person who had this book in the margin read, "Do I skip this chapter?" That's interesting. I just saw that right there, right? So it is a used book, but something that I got from a library many years ago on one of their book sales because I needed to know. Opinions don't they only hold for so long. When they get tested and they don't hold, you're gonna have to have something else to put in there, and hopefully it will be truth. Okay. So you guys sit back if you're so interested. I appreciate you guys for being here and try to listen attentively. And I'm going to try to read as precisely as possible with as much clarity as I can so that you guys can understand what the synopsis is. Again, this book is it's not about our layman opinion. These are people who have studied this, who possibly have access to the interpretations of the legal arena, one of them three branches of government, instead of our layman opinion, okay? Because they came out here with the lay people and start doing shit, in my opinion, okay? So I'm gonna start. I'm not gonna read there what this chapter explores, okay? Um, I'm gonna start at section A here, okay? We know we weren't naturalized, okay? But outside of the birth certificate, like I said, coming onto this level that I'm coming onto, I'm able to recognize some things. And many of us have not contracted with the government of our own will and volition, if you would, to understand those connections, what you do. Because just to give you an example, I'll give you an example on this family. I've been a truck driver for 25 years. Okay. I've been a company driver, and I've been a lease driver, and I've been an independent contractor. Some people may think that an independent contractor and an owner operator are the same thing. They are not. The independent contractor is about the closest that you're going to get to being an owner operator, if you would, because you got to buy your own shit and contract with the government. An independent operator can be a driver who's working under somebody who's an owner operator or has a fleet. This is what we're falling into in our regular circles, not truck driving, but regular circles. No, nothing new under the sun. Okay. So as a lease operator, one step below that, I can lease or rent equipment that will make me look like an owner operator, but not officially an owner operator until I meet certain criteria. And as I'm finding out, go through certain steps now, that as my sister, who's been out here for almost twice as long as I have, they didn't have to go through these things back in that time, but now they do. And in some aspects, they were already here. They just hadn't progressed to the point of being able to um, satisfy all the necessary things to make sure that the industry is regulated and that um, it's safe for the general public in a certain regard. I don't want to go too far in depth with that. But a company driver, they're not worrying about those things. And I can speak that from experience. So to translate that to our natural God's law, nature's law and nature's God, that we're just naturally an aboriginal, and before this government or whatever came into play, these men got together and did whatever they did for Congress or for the Constitution and the government, forming the government. You know, there is a difference. It's a commonality, but it's a difference. Um, how can I put this? We're down here arguing about, should we have a birth certificate? Should we authenticate the birth certificate if we were sold out by our mamas, not mama and daddy and parents, but mamas, um, with the birth certificate, and should we have a driver's license? That, for example, it's no, it's almost the same as saying, do I have a work permit? Y'all remember when y'all was 16 and y'all needed the work permit? Okay. And you had to have an ID and all this other stuff to get your first little fast food job or whatever the case is. Um, so just because they form these pieces of paper, if you would, does not mean that we give up our natural rights, if you would. I'm not saying this right. I know what's in my head. I just can't get it to come all out. Um, what's the thought that I just had? Uh, Damn, there was another thought that took over right there. The states. If I'm reading the right chapter, it will talk about how the states. I want y'all to hear me, okay? Because the people talk about sovereignty, but I think it's in this chapter here where it talks about the states had to give up part of their sovereignty for the federal government. This is where the fight was. We think it's colorism. It's not. Okay. So, and not to say it don't exist, because I know some of y'all be like, yeah, what a police do this and that's all out there. It don't mean it's right. It just means they're playing to a certain narrative. Okay, let's read. Fuck the dumb shit. Let's read. Race and the Constitution. Y'all pay attention to this. Maybe y'all can get away from this colorism shit and classism shit. But it says this section traces the evolution of constitutional doctrine concerning discrimination against African Americans. There are several reasons for beginning the study of constitutionality protected individuals' rights with this issue. Let me read that sentence again. There are several reasons for beginning the study of constitutionally protected individual rights with this issue. First, In one form or another, the controversy about the legal status of African Americans has been central to U.S. politics since the founding of the Republic. As you read through this material, consider the extent to which judicial decisions have shaped the controversy and the extent to which they have been shaped by it. Each stage, at each stage, could the court have acted differently? Was its powers meaningfully restrained by the language and history of the Constitution, by the constellation of social and political forces at that time? What? I told y'all I got some incomplete sentences, some things that didn't quite explain it. They threw me off. Let me try that last sentence again. At each stage, could the court have acted differently? Was its powers meaningfully restrained by the language and history of the Constitution, by the constellation of social and political forces at that time, by widely held ethical norms? Okay, so these are questions that are posed in here. All right, and I see the numbers have dropped because I know y'all, yeah, anyway, it's cool. Second, the court's analysis of discrimination against African Americans, and y'all know that's a made up term, against African Americans has served as a prototype for the development of other constitutional doctrines. Keep that in mind, other constitutional doctrines. This is where that one term comes out in the end, talking about, let me see if I can see it in here. Um, let's see. Other constitutional, I'm trying to remember what was the statement, something about the marketplace clause, market participation doctrine, okay? Market participation doctrine, okay? Which I've never heard that before until I read this link here. So again, um, discrimination against African Americans has served as a prototype for the development of other constitutional doctrines, one of those being market participation clause. In the 19th century, the argument over slavery provoked a fundamental realignment of federal and state power and gave birth to a new strategy for the protection of individual rights. Okay. In our time, controversies over uh, school segregation, racial discrimination, and access to political power and affirmative action have shaped attitudes toward the proper scope of constitutional protection for minorities generally. And before I read this question, in here, because this book was written before Roe v. Wade was overturned, because I think that's a whole hijack, okay? But not the overturning of it, because I do support individual choice, but for the way that it was pushed, um, and just to throw it out there, when we were dealing with the Black Power politics with King and all of that, and Rosa Parks, how Rosa Parks wasn't actually the one it happened to, um, and they didn't accept the woman who it actually happened to because she was pregnant, which had to deal with ethics and public opinion. You know how she would look to the public, how the movement would look to the public. They didn't want to use her, so they used Rosa Parks. But being that she was pregnant, it took from the time of Rosa Parks to Roe v. Wade, it took 18 years for them to get that court case into the courts. Just like when we're talking about Plessy versus Ferguson, it took so many years for them to find the proper case, which would have been what is it? Topeka versus the Board of Education or something like that. Brown versus the Board of Education. It took so many years from Plessy to get to that point, and then some, because they're talking about the slow moving judicial will, if you would, allows for a lot of propaganda to happen while stuff is going through the courts. you know like now, let me give you an example. Oh, I got a good example. I'll give you two. um Damn, damn, I just forgot the first one. Um, but how in uh, this thing with Anthony, Anthony and Metcalf. Before that can ever get to court, it's all kind of discussions going on online about it, and it's possible that whatever people decide in their own mind or push forward, it's going to be moved by popular opinion because people are putting things out there to make you think one way or another, and even putting information out there that may or may not be true to sway the public opinion before it ever gets to the legal arena fully. The other thing, to show it to you on a lower level, it just happened with BAP and OTK's debate. Okay. I don't like you playing with my intelligence. Okay. And if it's a debate, hey, what's the topic? What y'all gonna discuss? Okay, promote it. But when you have to start addressing the audience to say, oh, they're gonna vote this way because they're biased, and you got to explain what bias and unbiased is, and it becomes all these personal attacks. It's the same thing, trying to sway public opinion before you ever get to the real meat and potatoes, the day of reckoning. In that case, it would have been the debate, but it's already been sullied by the lead up to it. So those are two examples that I can use on the slow process of the judicial system and how that allows room for, you know, judicial stuff to come in. Okay, because apparently you can do what you want to until you get caught. Okay, but anyway, let's continue reading. Let me get that last sentence in. Okay. I can't get my lungs clear this morning or this afternoon. And so, first of all, so in here, when it talks about affirmative action, this again, this book was written before that was overturned. Okay. And before Roe v. Wade was overturned as well. And then, so next question says, to what extent is our experience with discrimination against African Americans generalizable? Generalizable, which I've never heard that word before, but it makes sense. Or having the ability to be generalized. Okay. Finally, a chronological examination of this issue provides insight into the influence of history on constitutional adjudication. What factors are most important in determining the course of judicial decisions? The strategy of individual litigants, the court's formulation of the issues, the reaction of the other branches of government. Does the Supreme Court ultimately have the power to impose its own solution to the race problem? Or are its decisions merely the product of broad historical forces over which it exercises little control? Now, when it makes this in the questioning part, when it says, does the Supreme Court ultimately have the power to impose its own solutions to the race problem? This is where that delicate balance of power comes into play with the slave state, free state, the 50% or 51% or above versus the 41% that it actually ended up being, so that the slave states wouldn't control Congress. Now, the bad thing here is that we argue as people in this community about these things, and it's like, did y'all want slavery to continue? Okay. Because on one side we're saying, hey, we were free, we were always free, and the government didn't have the right to X, Y, and Z. But then sometimes it sounds just like you just wanted to control slavery, or you were in favor of slavery, because then some people change the definition of what that is, and pulling up short of that, it becomes, who's a slave? The Slavs or Europeans? And it's like, y'all ain't, we're in the realm of public opinion because you really haven't got to the real judicial problems, in my opinion. Okay. Um, so could they impose their own solution on the race problem? And this is where Taney comes in at, and that blunder that he made, because it was a delicate balance that they were having a problem with. Now, on one side, I was like, y'all should have voted in favor of, getting rid of this at this point. But when you understand that delicate balance, maybe you can have some empathy for what happened in there in the process of the evolution of judicial the Constitution, if you would. Okay, but anyway, let's continue. Let's go. Section 1, slavery in the Constitution. And I hope some of the questions you guys wrote down, because this is not just somebody's opinion. This is actually what was being studied and what has been studied in legal circles. Okay. 1, slavery in the Constitution. 3 provisions in the original Constitution recognize and arguably legitimate slave. What? Oh, arguably legitimate slavery. Article 1, Section 9 prohibits Congress from outlawing the slave trade until 1808. Article 1, Section 2 requires apportionment of legislators on the basis of the whole number of free persons in each state and 3/5 of all other persons. Okay, pay attention. It was right in there. States, state in each state. Okay. Um, maybe okay. Maybe you counted 3 groups and didn't count 5 groups. Okay, but anyway, it could be a few different ways. But I'm keeping it to states' rights versus federal rights. Okay, and then of course individual rights. Um, Article 4, Section 2, Clause 3 requires states to deliver up escaped slaves and prohibits states from discharging them. Okay. Now that would be something to climb into or dive into a little bit, because that was one thing that I thought of in this narrative of, well, we wasn't supposed to have slavery, or the delicate balance between slavery. Well, here comes the Fugitive Act. Okay. Well, who put it out? What areas did they control? These types of things. Was it all inclusive for every place, or just somebody operating in their small window of authority? Okay. um, it says, do these provisions make the Constitution a pro-slavery document? Consider Robinson, Slavery in the Structure of American Politics, 1765 to 1820, at 208, I'm sorry, at 209, at 210, and then also pages 244 to 246 in the year 1971. Here's the excerpt. In the drama that produced the Constitution, Southern delegates were unmistakably prominent players. James Madison, the man whose leadership during the convention earned him the title Father of the Constitution, was a Southerner, a slave-owning Virginian. John Rutledge, certainly a leading nationalist and chairman of the important Committee of Detail, which is official, Committee of Detail, was provided the first definition of legislative powers under the Constitution. Um, I'm sorry, let me go back, because I realized that was not a period, but a comma. Okay, let me go back. John Rutledge, certainly a leading nationalist and chairman of the important Committee of Detail, which provided the first definition of legislative powers under the Constitution, was one of the wealthiest and best established planters at the convention, and deliberately represented the most candid slave owners. George Washington was an exceedingly rich man whose fortune arose largely from the labor of slaves in and around Mount Vernon, Virginia. In fact, the 15 delegates whom Clinton Rossiter, Rossiter, has termed either principals or influentials, 7 were planters. The South's, the South's enthusiastic participation in the nationalization, I'm sorry, the South's enthusiastic participation in the nationalizing thrust of 1787 carried one portentous qualification. The national government could be as powerful as the vision of a great national empire demanded, provided that it keep its hands off slavery. The framers dealt with slavery by seeking, as far as possible, to take it out of the national political arena. They were unable in 1787 to settle the issue one way or another. They could not establish straightforward constitutional guarantees against emancipation as the South Carolinians desired, because many Northerners and perhaps some Southerners would not permit it. Nor could they give Congress the power to regulate slavery in any way, much less abolish it, because Southerners refused to yield control over the institution. Realizing that it was utterly beyond their power to fashion a national consensus on slavery or to govern the issue of the in the absence of one, they had contented themselves with measures aimed at preventing friction over slavery between the states and the sections. End quote. There is no evidence that any framer thought the Constitution contained power to abolish slavery. They all knew how the deep Southerners felt, and however much some of them may have regretted the hold that slavery had on the South, they were all fully sympathetic with the determination of the deep Southerners to resist Appalachian in the present circumstances. But there's no guarantee that powers of emancipation were forever denied to the federal government. The evidence there is permits what? The evidence there is permits. The fuck kind of sentence is that? Excuse me. Okay. The evidence there is permits the conclusion that the future, with respect to possible public action against slavery, was left open on purpose. The framers, as of 1787, agreed unanimously to place the institution of slavery as it existed within the South, not on the course of ultimate distinction, as Lincoln argued, but beyond national regulation. In light of the provisions in the Constitution protecting slavery, should it have been ratified, consider the views of Justice Thurgood Marshall. Quote, I do not find the wisdom, foresight, and sense of justice exhibited by the framers particularly profound. To the contrary, the government they devised was defective from the start, requiring several amendments, a civil war, and monumentous social transformation to attain a system of constitutional government and its respect for the individual freedoms and human rights we hold as fundamental today. End quote. And they don't have the quotation marks here, but it was a quote. And that's the thing that they said in the 1776 project book that people have ignored. Okay, that particular protocol from Trump is that when the Constitution was formed, everybody knew that it had to um, progressively be changed to address all the things that needed to be addressed. Um, they said in the writings, and I've heard before, that they thought it was weak from the beginning. So Thurgood Marshall is just solidifying that fact that we've heard before, at least I have heard before. But does that mean that we get to abolish it and just throw it away and create a new one? Or do we continually build on it? And where are we in the building of it? This is how they still keep us away from the government, because they keep us in this victim mindset, pointing fingers at one another, like Adam and Eve, okay? Instead of getting into those particular arenas, information or no, and addressing those things as they play out, not as we wanted them to play out or we perceived them to play out, but as they actually played out. Okay. So let's continue. Marshall commentary, reflections, and I guess this is where it comes from, and maybe another quote here, but reflections on the bicentennial of the United States Constitution, 101 Harvard L. Revised 1 2 1987. Compare Livingston 1787, The Constitution in Perspective, Pledging Faith in the Civil Religion, or which you signed the Constitution. 29, William and Mary probably college, L revised 113133, 1987, and it states here, the central problem was disunionist, disunionist, okay, thinking, um, is that it focused more on the immorality of collaboration with slavery than on the question of how one must quickly, how one most quickly can bring slavery to an end. We know that with ratification, chattel slavery ended in 1865. Is there good reason to believe that it would have ended earlier had the Constitution not been ratified and balkanization followed? I suspect not. But the important point is surely this. Can one who believes that the ratification of the Constitution did enhance the prospects and actuality of chattel slavery sign the Constitution? Let me read that again without the parentheses. Can one believe that the ratification of the Constitution did enhance the prospects of chattel slavery sign the Constitution? That just sounds weird. And that was a question. It says, what precisely is the value of the Constitution and of the concomitant nation? Concomitant nation that would justify even an extra week of slavery or extra week slavery. What precisely is the omelet that justified breaking those particular eggs? Here they have a court case. And sometimes these questions can be a little confusing, so I can see why people can't have debates on shit. But anyway, hope y'all still here. I still see y'all here, but hopefully we can get into something. I'm trying to get to those points. Again, this title is The Naturalization Act, Dred Scott, and a New Take on It. And you'll see why I say a new take as we get further into this. J. Nuvius, State versus Post, 20 NJL 368, 1845. J. Nuvis. The proceeding is designed to present for our adjudication the question whether slavery can exist within the limits of this state under its present constitution and laws, and it derives signal and solemn importance from its bearing upon a class of human beings still claimed to be lawfully held in slavery, and upon the interest of those communities where most of that class is still found. I have listened with great pleasure and deep interest to the arguments and remarks and the pathetic appeals which have been argued before us in support of this demur and in behalf of the colored race. And whilst I most certainly respect the zeal and humane spirit by which they have been dictated, and the ingenuity, talents, and research of the council, I am nevertheless constrained to say that much of the argument seemed rather addressed to the feelings rather than the legal intelligence of the court. This is 1845. They were saying that, and we see the same thing happening today. Um, anyway, this might be a judge here that's saying something. I'm not sure. It didn't say who he was, just where you could find this, which was in the court case State versus Post, 1845. It continues. In 1804, the legislature adopted a plan for the gradual abolition of slavery and passed an act declaring, quote, that every child born of a slave after the 4th of July of that year should be free, but remain the servant of the owner of the mother until he or she should arrive at a specific age, end quote. Under the operation of the statute and the benign spirit of the age, which inclined men to manumit their slaves, slavery has become nearly extinct in this state and must soon pass entirely away. According to the last census, the number of slaves was reduced to 674, of whom 348 were over the age of 55 years. Those who yet survive and have not been manumitted remain still the slaves of their masters, but have a legal claim upon the latter for maintenance in the case of their inability to support themselves, unless by the provisions of the new Constitution framed and adopted in 1844, slavery is abolished. If such be the case, it would follow as a legal consequence that masters too are absolved from the obligation of maintenance. These consequences, while they have no legitimate influence upon the decision of the question, nevertheless give it more than ordinary importance and call for our most serious and anxious consideration. Abolitionists, argued that slavery was made illegal in New Jersey by a provision in the state's 1844 Constitution declaring that all men are by nature free and independent and have certain natural and unalienable rights, among which are those of enjoying and defending life and liberty, acquiring, possessing, and protecting property, and of pursuing and obtaining safety and happiness. If the New Jersey Constitutional Convention intended to say that all men in a state of civil and political society were free and independent and entitled to the exercise and enjoyment of the rights mentioned, the expression must be understood in a modified sense according to the nature, the condition, and the laws of the society to which they belong. For man, under no form of government, can be said to be absolutely free and independent and have the absolute and uncontrollable right over his own actions according to his own free will, unrestrained by the rights of those and the laws of the government under which he lives. And I have to let y'all know that free will in this writing is two words. It's not a compound word. Anybody who's been on my channel and really been rocking with me over the years will know that when I started to talk about what do I mean when I say mean several years ago, that this is where we identified free will as a compound word that sent you into a religious narrative as opposed to free will, two words that did not. Okay, so let's continue. But here it was free will as in two words. Welcome, Enots. Authority and subordination are essential under every form of civil society, and one of its leading principles is that the citizen yields to it a portion of his natural rights for the better protection of the remainder. In such a state, man's right to freedom and independence, to enjoy and defend life and liberty, to acquire, possess, and protect property, and to pursue and obtain safety and happiness are ever subject to and regulated by laws, fundamental or otherwise, which the majority of the people in a republic have established for their government. Had the convention intended to abolish slavery and domestic relations, well known to exist in this state and to establish by law and to divest the master of his right of property in his slave and the slave of his right to protection and support from his master, no one can doubt by um, no one can doubt but that it would have adopted some clear and definitive provision to effect it. I and I'm sorry, no one can doubt but that it would have adopted some clear and definitive provision to effect it, and not have left so important and grave a question involving such extensive consequences to depend upon the doubtful construction of an indefinite abstract political preposition. I hope y'all understood that. I'm sorry, I really kind of wasn't paying attention as I was reading because I was thinking about how that protection thing um, applies here. I want y'all to notice that right there, the person did not use sovereignty, they use natural rights. Okay. He lends part of his natural rights. Okay. and not his sovereignty, two different things. Because I also read that it was the states that lent their sovereignty to the government. Okay. Now, which makes them the first citizen. Okay. But one of the thoughts that I was having here in this part where it talked about the protection of his master. Okay. You know, I hope y'all understood what they were saying there. He free and he set free. But they have to maintain, you know, you want this, you got to take care of the maintenance on this. I thought about how in our society we have a tendency to say, hey, you 18, you can get the hell out the house. I ain't got to provide for you. But those people who, in my opinion, what I've seen, those people who really still love their children, respect their children, care about their children, know that when that child turned 18, you still helping that child. Okay. Um, you're not just throwing them out to the wolves, but in some aspects, it almost seems like we have adopted this mindset of throwing our children to the wolves once they reach adulthood. Okay. And I might not be all the way clear about that in my understanding, but I'm speaking from kind of my perspective because for those of you who don't know, and this is personal, but for those of you who don't know, my mother passed away 13 days before my 18th birthday. Okay. And then when I returned to my father's house, he kicked me out the house. Okay. On some bullshit. So I'm speaking from an experience that I have and a knowledge that I have because I have children that it was more advantageous for me to be in the truck with, to be in the truck after certain times so that I could help them with my own limited resources. So we don't just kick them out. So this is very natural, but this is not, we're not talking about natural stuff. We're talking about what they were doing in the political arena. Yeah, yeah, it doesn't. Give me just a second and I'm going to continue reading at the next paragraph. But that's why my thought was divided on that. Um, because in this, it's like, hey, if you let the slaves go, whatever, okay, then what do I get? I just lose out. It's not fair for me. And then on the other side, the so called slave is going, um, you know, who going to take care of me? you know, I'm free, but then who's going to take care of me amidst this political environment, if you would? Um, you know, leave me alone. I do it for myself. I get that, but what I'm saying is sometimes you can't make everybody happy, okay? You know, and I think that's the delicate balance that we were looking at, that some things you just got to give up, okay? Some things you just got to give up, okay? Um, which makes this whole we gonna get reparations thing kind of funny. Uh, you can always go back to your masters. They're supposed to take care of you. Go tell them they take care of you. But y'all gonna have all this legal shit to deal with while you're doing that, okay? Because it's about what they were talking about in the legal arenas, not our emotional stances on things. But also, I can actually agree that this should have been taken care of at the onset, but there was things that were going on, okay? You know, between the free states and the slaveholders and the non-slave holders, and you know what you had a right to do, who had a right to tell who what to do. It was something newly being formed. I mean, we do this same thing in our community. We create a type of organization and then argue about who's going to run the damn organization. And at least for those that jump out here in the public, because you can see this on these channels, we got people over here vying for the first seat wherever the fuck the first seat is. Okay. Like we're all followers. I did this first and I've been doing this the longest and I started this and okay, but yet you got other people that thinking blah blah blah, they need to come up against you because you ain't. We do it right here on social media. Okay. You can't tell other people what they have to do unless they've agreed to that. And what's good for you may not be good for someone else. Okay. Um, Let me continue because I was going to say some shit right there, but I'll leave that alone. Let me continue reading. The Declaration of Independence, the basis for our free government, declares that all men are created free and equal, and the Constitution of the United States proclaims that the people have formed it to secure the blessings of liberty to themselves and their posterity. Yet, by the express language of the latter instrument, the relation of master and slave is recognized, showing that the framers of that Constitution did not deem their general declaration in favor of liberty incompatible with its other provisions. And it has never been judicially determined that slavery in the United States was thereby abrogated. On the contrary, it has been often adjudged, both by the state and federal courts, that slavery still exists, that the master's right of property in the slave has not been affected either by the Declaration of Independence or the Constitution of the United States. It was argued before us that under the Declaration of Rights in the Constitution of Massachusetts, which contains the same language, it has been judicially held that slavery was no more. And we are referred to Commonwealth versus Ives, AVES, 18, PICK period, R 193, okay? And that's the reference, Commonwealth versus Ives, okay? In Ives, Chief Justice Shaw declares, quote, that slavery is contrary to natural right, to the principles of justice and humanity, and repugnant to the Constitution, end quote. I am unwilling to yield to anyone in high respect for the Supreme Judicial Tribunal of that enlightened state. But I do not find the reason or argument which satisfies my mind of the soundness of its conclusion. How far the humane spirit, mm, how far the humane spirit of abolitionism, which prevailed in that state, the fewness and of worthlessness of that species of property, the feebleness of that defense made by masters, or the collateral mode in which the question was presented, or the fact that slavery had only been tolerated but never actually established by law, may have influenced the opinion of the court. I will not undertake to determine. By this remark, I mean to cast no imputation upon the judicial intelligence or integrity of that court, but judges must be more than men if they can always escape the influence of a strong popular opinion of society upon great questions of state policy and human benevolence, which have been long agitated and much discussed. It is no matter of surprise that Chief Justice Shaw, entertaining the opinions he did upon the question of slavery, should have found it repugnant to the spirit of their Constitution. Note, okay, note. This is we're gonna run into Scott right after this next these next parts of the reading. Note, constitutional attacks on slavery. 1. Post and the problem of judicial power. For 150 years, U.S. courts have vacillated between attempts to impose a judicial solution to the race problem and attempt to leave the matter to the political process. In post, the court chose the latter course, to leave it to the political process. Um, is the decision an example of moral cowardice or fidelity to law? And that's one of the things that I like about this, the reading of this book, which I had to go on and suck it up and actually read all of it instead of just picking and choosing, is that they ask questions that a student who would have been taking a course like this would have had to answer. Okay. And some of us don't in many regards. We bypass stuff, if you would. And even when they start to talk in these legal jargons and long wordy sentences and all of this other stuff, sometimes we don't have a comprehension for that language. Okay, because like some people say, when you start reading this, you should have about six dictionaries and thesaurus around you so that you can look at this. We're not doing this. We're on panels trying to talk on the fly about stuff. Okay, we know the argument, but how to get to the solution is difficult. And in my opinion, one of the ways to get to that solution is to realize what it was really about, and that it wasn't about colorism, although they made it about colorism and your skin color. Okay, as long as we stay in that mindset, you might as well work at McDonald's. Okay, you don't have a career, you got a job. Okay, matter of fact, speaking of job, I listened in the past 10 hours. Well, I think I was listening on and off yesterday, but let's say the past 10 hours, 12 hours since last night or whatever. And the book of Job came up in my mind. And I'm not being religious. I'm just talking about how they all got together and started saying shit and talking shit and this, that, and the other about Job and what he was going through and how he was going through it and who he was and who he wasn't. And all to the point of somebody blessing him or him getting blessed and restored, everything being restored. The panel actually sounded like the book of Job. Okay. But anyway, let's continue. Answering some of these questions would do us justice. Okay. You know, so, and that question was, is the decision an example of moral cowardice or of fidelity to law? Okay. It says, was the court bound to reach the result it did by the words of the provision in question, by the intent of the framers? Where else might it be looked for, or where else might it have looked for guidance? And it says, see chapter 1, section 1, see SERPA, whatever, whatever. And I'm not doing that. Some of these questions I'm not even considering answering, okay? Because it would be of no avail to me. But anyway, it says, do you agree with Justice Nuvis that judges should attempt to escape the influence of strong popular opinion of society upon great questions of state policy and human benevolence? That appeals, it says that appeals to feelings rather than the legal intelligence of the court are inappropriate. Okay, that appeals, do you agree? Blah, blah, blah. That appeals to feelings rather than legal intelligence of the court are inappropriate. What exactly does the court mean by legal intelligence in this context? People are having conversations about lawful and legal, and right now, I think the buzzword right now is jargon, legal jargon, whereas before it used to be legal ease, and that's why y'all stay in Black's Law Dictionary. But what is legal intelligence? Okay, we'll say it in other circles. We'll say it about competency. Okay, but what is legal intelligence? Okay, is it just an appeal to feelings? Okay, emotionalism, how you feel about it? Because I feel a certain way about it. I don't think people should have been in slavery. But what I do say is that if you got into a contract and you signed a contract, whether your thumbprint, your X, your word, whatever the case is, you should have been made to fulfill that contract. Okay, and to some that may feel like slavery, and up until the race issue, the race as far as dark skin, light skin, this, that, and the other, all that shit, up until that point, I think that's what it was, because I can't help look at the fact that you got domestic and you got foreign, and some of the foreign influences are people who probably got kicked out over with Cromwell and them, or got scammed to sign a contract over there in India and ended up over here as indentured servant to find out it was some bullshit. I mean, there was a story that I had read when I was looking or listening to, when I stumbled across this Scottish guy on YouTube who was bringing out some of the Scottish history and stuff. And in one of his, he talked about this one man This one man from here, and I want to say it was like kind of like the islands, if you would, who went over there, and even though he knew, I think he knew mining or something like that, that they wanted to make him a slave. And it was an assumption that whatever the hell they were doing over there with the so-called um, white lower class, if you would, the coal miners, that whole profession, that that's what was going on over here with dark-skinned people. And based on that information that we were looking at, it was not. We had something different. I think they were trying to impose something um, which in many aspects was not what we did. Even in the historical accounts, some of the readings and stuff, they'll tell you that what they consider to be slavery over here, okay, before the Constitution and all that other shit, that and even probably before the fucking Columbus narrative, that it was not like what they instituted later, especially when you talk about these people are whatever people those are going to be in servitude for life, okay, based on their skin color. I mean, in some aspects it's like, who did those people offend? Okay, when they were throwing their prisoners out from over there and bringing them over here, who did they offend? Were they sitting there, were some of them people, okay, sitting there or involved in uh the overthrowing of a monarchy over there, okay, and you know and then sent over here, because they said basically you can sit in prison over here for a life, for the rest of your damn life in this dungeon, or you can take your ass over there and work the rest of your life off. We don't give a shit, okay? And who did they offend? I mean, is it a difference between a misdemeanor and a felony? And I'm not law enforcement and I'm not a police officer, okay? But was it a difference between a misdemeanor and a felony? Is that what determined the harshness that you received being put in labor camps called plantations and an institution called slavery? Are we not adding this to the narrative? Okay, possibly because of our lack of understanding about world history. Just some thoughts I had. They post thoughts, I post thoughts. Okay, questions. All right, where are we at? Where are we at? Let's continue. Um, so here, what exactly does the court mean by legal intelligence in the context? Okay. So I just added a few of my own. Appreciate y'all for being here. It says Justice Novus says judges must be more than men to ignore the strong public opinion. Does this susceptibility to public pressure suggest that he should have used his power more confidently? How likely is it that a court would construe the Constitution in a manner most people violently opposed? That it would succeed in enforcing such a construction in the long run? Is the 1804 statute providing for gradual manumission and welfare protection for the remaining slaves relevant to the court's decision? For a discussion, see R. Cover, Justice Accused, 54 through 55, 1975. Just on that on that right there, let me put these questions into another context as well, because sometimes these questions be getting on my nerves. But let's put those questions into context a little bit further to understand how these things play out, and also may leave us in a place of laziness where we don't want to answer them or don't even hold credence to some of the questions that are asked. It's no different from the biblical text. Is it true God said? It's the same shit. It's the same fucking shit. Okay? From the biblical text. Is it true God said blah blah blah? Yeah, same shit. Okay? But anyway, let's continue. Uh, Um, of course, in a southern state in 1845, a judicial decision abolishing slavery would have been revolutionary. If a southern judge had written such a decision, what do you suppose the result would have been? Okay, let's go to section 2 or part 2. Constitutional attacks on slavery. Okay, Post typifies judicial analysis of slavery prior to the Civil War. Although abolitionist lawyers won isolated victories, even judges strongly opposed to slavery usually ruled against them. See generally cover super semicolon L. Levy, The Law of the Commonwealth, and Chief Justice Shaw from 1957. Okay, we can make up our own stuff, but sometimes you got to go see what they said for real, for real. Because if you don't, you're going to end up with an attenuate trying to tell you every damn thing. Anyway, my bad. Let's continue. Although Post dealt exclusively with state constitutional issues, Alvin Stewart, the abolitionist lawyer who argued Post, relied on the federal constitution as well. C. J. Tenbrook, or Tenbrook, broke, the anti-slavery origins of the 14th Amendment, page 43 through 45, 1951. For those taking notes, J. Tenbrook is J, whatever his first name is, Ten, capital Broek, if you guys are looking for that. That's Tenbroek. All right. See also E. Foner, Foner, free soul, free labor, free men, the ideology of the Republican Party before the Civil War, page 76 through 77, 1970. Okay. It says here, Stewart claimed that slavery deprived slaves of life, liberty, and property in violation of the Due Process Clause of the 14th Amendment, that it deprived New Jersey of a Republican form of government in violation of Article 4, that it violated the preamble of the Constitution, and that it violated the Treaty of Ghent, which outlawed the slave trade. Ooh, we the treaties that came before. Okay, never mind. And this Constitution. Okay, that part. Um, C. Ernst, Ernst, legal positivism, abolitionist litigation, and the New Jersey slave case of 1845. Uh, 4. Law and History, revised 337, or page 337, 350 through 351, 1986. Okay. And y'all can play that back if y'all need to actually hear what I just said, for the reference. But then it says, the court apparently thought these arguments too flimsy to merit a response. Are the arguments tenable? Okay. Number 3, I'm probably going to ignore some of these questions in a minute, but anyway. Um, Number 3, judicial support for slavery. From the perspective of the present, and just to reiterate what's going on here, this is a precursor to the Dred Scott, okay, to them talking in intellectual circles or whatever, the courts or whatever, about Dred Scott. Yes, there is some emotional shit here because there was something that was mentioned inside of the Dred Scott that kind of pissed me off, like they're saying here. um we know this shit violates human rights, but it seems like they supported it, in my opinion. So it kind of pissed me off, but I worked through that thought and feeling to understand something beyond that, what was really going on in Dred Scott, okay, that led to the Civil War that we're still confused about today. But anyway, let's continue. Judicial support for slavery. From the perspective of the present, it may be seen that courts should have done more to combat the evils of slavery. In fact, however, when the court did intervene in the pre-Civil War period, it was more often to invalidate political arrangements that tended to limit slavery. Most of the federal litigation centered on the Fugitive Slave Clause, Article 4, Section 2, which required the return of escaped slaves. In Prigg versus Pennsylvania, and Prigg is Prigg, versus Pennsylvania, 41 U.S. 16 Pete, or PET period, 539, 1842, Prigg versus Pennsylvania, 1842, the court, in an opinion by Justice Story, held unconstitutional a Pennsylvania statute prohibiting any person from removing blacks from the state by force or violence with the intention of detaining them as slaves. The court explained that Article 4, Section 2, quote, contemplates the existence of a positive, unqualified right on the part of the owner of the slave, which no state law or regulation can in any way qualify, regulate, control, or restrain, end quote. Okay. The court, therefore, held the statute invalid as applied to an escaped slave because, quote, any state law or state regulation which interrupts, limits, delays, or postpones the right of the owner to the immediate possession of a slave, the immediate command of his service and labor, okay, service and labor operates pro tanto a discharge of slavery therefrom, end quote. Okay. Delicate balance, right? Delicate balance. The court further held that Article 4, Section 2 implicitly vested Congress with the power to assist owners in securing the return of escaped slaves. That Congress had exercised that power by enacting the Fugitive Slave Act of 1793. That this national power was exclusive and that any state laws regulating the means by which slaves were to be delivered up were unconstitutional. Specifically, Prigg seemed a pro-slavery decision, but its legacy was ambiguous. The decision left intact the power of both free states and the national government to limit the growth of slavery by freeing slaves brought into free areas. See, we're getting ready to get into Scott right here. Okay, let me read that again. And for the confusing part, I'll start back here. The court further held that Article 4, Section 2 implicitly vested Congress with the power to assist owners in securing the return of escaped slaves, that Congress had exercised that power by enacting the Fugitive Slave Act of 1793, that this national power was exclusive, and that any state laws regulating the means by which slaves were to be delivered up were unconstitutional. Specifically, Prigg seemed a pro-slavery decision, but its legacy was ambiguous. The decision left intact the power of both free states and the national government to limit the growth of slavery by freeing slaves brought into free areas. Moreover, by nationalizing the rendition question, the court relieved free states of this distasteful obligation and intensified the political struggle over the future of slavery on a national level. Okay, I hope y'all understood that. C5C Swisher. Swisher, like the cigar, Swisher. History of the Supreme Court of the United States, the Taney period, 1836 to 1864, at 546, 1974. Okay, it says for an argument uh, that Justice Story's anti-slavery reputation is overblown. See Holden-Smith, Lords of Lash, LASH, Loom, LOOM, and Law, Justice Story, Slavery, and Prigg versus Pennsylvania. 79 Cornell L. Revised 1086, 1993. Okay, I'm not repeating that, so if y'all need to have that reference, just go back and rewind it. 15 years after Prigg, the court attempted to cut off the political struggle in an opinion that preceded the Civil War. Mhm. Number 4, the road to Dred Scott. Consider D. Fahrenbacher, the Dred Scott case, its significance in American law and politics, 192 through 194 and 206 to 208 in the year of 1978. We got one paragraph before we get into Dred Scott versus Sanford. Okay, so here it says the pressures for judicial intervention in the mounting sectional conflict over slavery were very strong. Um, the tendency to constitutionalize the territorial issue dated back many years. It was reinforced in 1856 by the peculiar needs of the Democratic Party and and especially by the strategy of unity through evasion, with a consequent increase in talk about leaving it to the Supreme Court, end quote. The court, furthermore, was the one major agency of government that had not yet tried its hand at resolving the conflict. More than a few Americans apparently believed that at its command, agitation of the slavery question would subside and the years of crisis would come to an end. Indeed, some members of the court itself seem to have harbored the belief that it possessed some such extraordinary power. Okay, so I'm gonna go grab me a little drink and then we're gonna get into Dred Scott versus Sanford. Again, there are some challenges and some nuances in here um, that's very difficult to like suss out sometimes. We know what we want, okay? Some of us know what's right, but we got to go against those who don't know what's right because or don't agree with us because in some aspects, you know, let me go back to trucking for example, okay? If I can, just to use that for an example. Um, back when I started, some of y'all might laugh at this because, but it was worse for other people. Some companies said you get paid 32 cents a mile. Let me stop lying. I think the first company said something like 24, 25 cents a mile. Okay. Um, and then others will say, hey, well, I'm gonna offer 32, you know, and others might be like, well, I'm gonna give you a percentage and different things like that. Well, who's wrong in this? Negotiating their own interest. Okay, who's regulating that to say that you can't do this? And I think that's kind of what they're looking up against. It's like, this is business. Okay, I'm talking about my bottom line. And to keep my business going and what I got going, why can't I do this? Okay. Um, because of this whole free government. Some people might think that free government means that everybody's free. No, maybe it's just you have the freedom to govern. Whereas some people might not have had that right and that ability coming from other places because they might have been under the monarchy, okay, or aristocracy, or the elite controlling everything, okay. Now where they're trying to give it to the people under this new republic, because some shit has happened, okay. Shit, in some aspects, our ancestors here on this land prior to the 1700s, prior to 1619, prior to 1492, might be responsible for some fuck shit. I mean, even when you look at my family, okay, um, some family names that pop up. Shit, it was one brother that went against the rest of the family, and it was a whole war over there, and people losing they right of inheritance, and some of those rights being transferred to other family members. And these are some well-known names if you know the history. Okay. But that's neither here nor there. Okay. Um, so it's just not a matter of this basic ass question, because let's go to trucking. Okay. Knowing what I know now, if I hear people in a company aspect talking about shit that they got a problem with the industry, as I did in times past, I'm gonna become real silent because I know some shit now. Okay, um, that some newbies may not notice or know. Let me throw this in here. Like I said, I'm trying to set myself up for this Drew part that's coming in. Okay, or Dred Scott the part that's coming in. Um, hmm. There's some stuff that I know about trucking now that I didn't know before. And some of the shit, looking at it from where I'm at right now, don't make a bit of sense. But going back to trucking when I was company, I ran into a brother that was being trained by one of the trainers at our company. And when I pulled in, I was on my shit that day. And I pulled in and tap 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 boom. And I backed that thing up, right? Okay. And I had to meet with them, but they were able to watch me when I came in, and I wasn't really paying attention, and I was just trying to get the truck parked. And when we got into a conversation, the trainee was like, "Yeah, you really did that. We was watching you, and da 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 da, all this stuff, right?" So as it turned out, me and that young brother, we started talking, and this was 2009, 2010. And we started talking. We became friends. We were friends for a good long time, and he started to go, I'm gonna own my own truck. I'm gonna get my own truck. I'm gonna have my own authority. I'm gonna do this. I'm gonna do that. I'm gonna make all this money, all this other stuff. And because I had already been in the industry for 10 years, I told him, I said, you're gonna have to pay your dues. Okay. And as the years progressed, we would have have conversations, but he would sometimes bring that back up. He said, you're the only one that told me I was gonna have to pay my dues. And what that did was slow him down in this money grab that he was having, because I too remember when I first came into it and people telling you, hey, here's this new career that you go into, we're gonna train you, you're gonna do this, you're gonna make this, and work for this company. And then there's other people who say, you can lease your own truck and you can do this and you can do that and you'll make all this money, be your own business owner. And it was because of my sister and my nephew that I had to go to be like, okay, I'm new in this. What's up? Asking them questions. And it was my who was it? It was my sister. Um, she said, before you do any of that, learn the industry. Okay. So that translated to you're gonna have to pay your dues. And some of those dues entering into trucking was, they know you don't have the experience, they know you don't have the knowledge, you don't know how this whole thing goes. So they gonna give you the least amount you can make. They're gonna give you the worst loads that don't nobody else want, because the veterans know what it is. Okay. Um, and because you're signed into a contract, you can't say no. There's some companies that I won't mention that will take students, people who have come out of um, a school like I went to, or will offer you the training, but then you're stuck with them for a 2-year contract. That's still the same shit. Indentured servitude and slavery until you decide to quit. What they're saying here is that at this particular moment in time in history, some of these people in these slave states didn't have a right to quit because they needed their labor. Now, I'm not agreeing with slavery. I'm just agreeing with the business owner that said, hey, you signed on for this shit. I'm not agreeing with the business owners who cheated people out their money, okay? Which we've seen in Hollywood productions, because I ain't seen it in real life. I just know some real life situations, where they start nickeling and diming you, Like some companies, even today, to show you the progression, some companies today who will have all these hidden fees, if you would, okay, or some companies today that'll have 500 drivers. Let's just say 500 drivers, okay, and they'll take $5 for 500 drivers, and that $5 don't mean a damn thing in some circles to the individual person, but when you multiply that $5 times 500, that's a number. That's a number, okay? Or you figure it out another way. They got way more drivers and they take way more nickels and dimes and quarters from people and they put it into their little slush fund, okay? You know, and that's what's going on. And I don't agree with that, okay? Um, and in certain circles, that's the difference between the wage earner and the business owner, okay? And we still got our issues. And like I said, I'm just now starting, so I'm officially, unofficially a business owner, put it like that, okay? I'm figuring it out. But in this aspect, on this side of the fence, I saw some more shit. I was like, oh, really? That's what we doing? We got processing agents in the middle of this shit that's lying they through their teeth because they got a little bit of access and a little bit of certification, signed up for something. But what these service people are offering vary a lot. Let me show you the variation on this. And I know some of y'all aren't truck drivers, and this may be tedious for you, but you guys know about the 3 letters that they sent me demanding that I pay some money because they were going to close the business and stop this, that, and the other, which weren't even official documents. They were just made to look official. Then once I got what I, you know, needed, which was actually last week when all these damn phone calls started coming through, um, people started telling me, the next process of this, what I needed to do, how much it was going to cost to satisfy these various requirements. Was it 10 different avenues or 15 different organizations? Some shit like that. It's a lot of them, okay? Um, and I happened to get the numbers on one of what I would need to pay, okay? Because I got some things I got to do. And then we went a little bit further, and there was some bullshit that happened. We went a little bit further, and I started asking specifically, what do you do? Who are you? This, that, and the other. And I had some people lie to me, but it was this one fee that really exemplified the bullshit. And that was the first person told me that it would be $375 for something. And the last person told me it was $25 for that same shit. Okay. So people have a right to do stuff because it's a free government. It doesn't mean that it's ethical to do that thing. Okay. But when we talk about the government, you got to notice that nuance of, are you asking them to totally take care of you, to provide for your maintenance? Um, or are you trying to get on the other side of that and be a business person, if you would, and provide for your own shit without excuses on why you can't do stuff like you're a company driver, if you would? Yeah, it's some nuances in there. I'm just, and I add some of this because I'm thinking about, and my daughter suggested the same thing. She didn't even know that I was thinking about this, but I'm thinking about using my backup channel to show the process of um, getting your own authority in trucking. Okay. Um, and if I do that, it's going to be at fee um, rate. I'm going to charge for that. Okay. Um, that way we can keep some of the riffraff out, and only people who are serious can actually show up. So if y'all don't understand why these trucking narratives are coming in here, it's because that is also on my mind as well. for the concept of what we're looking at: slave or free, company or owner operator, these types of things. But I think I'm just about ready to jump into this Dred Scott. Okay. And I do appreciate those of you who are in here. Okay. But again, I'm thinking about using my backup channel for that as I go through this process, because there's some interesting shit going on behind the scenes. I didn't know I was going to have to take a whole course, but I appreciate the course because without the course, the official course, you're literally thrown to the wolves and not knowing that some of these people are wolves in sheep clothing. Let's get into Dred Scott versus Sanford. Okay, there's a nuance in here, and again, I'm gonna state it. And y'all may think it's embarrassing for me to state this. You may think that it expresses my naivety in saying this, but I think that you're no longer a slave when you have the ability to contract with the government. Let's get into Dred Scott. Page number 501. Dred Scott versus Sanford, 60 U.S. 19 How 393 1857. Mr. Chief Justice Taney delivered the opinion of the court. Dred Scott, admittedly once a slave, by claiming now to be a claiming now to be a citizen of Missouri, brought an action for trespass in the Circuit Court of the United States for the District of Missouri against John F. A. Sanford, a citizen of New York. Federal jurisdiction was premised on diversity of citizenship. Okay. Um, I think they're going to make reference to New York abolishing slavery prior to any of this. So that's going to be really interesting too. And even right here, that's what I'm looking for. Even right here, I always thought that Sanford came from a southern state. Now what you're saying that he was in New York? Well, that adds some sugar to the shit, don't it? Or some shit to the sugar, one or two. Okay? Because I always thought he came from a southern state and came up to Missouri or east to Missouri. Okay? But let's continue. Um, Sanford, a citizen of New York. Federal jurisdiction was premised on diversity of citizenship. In 1834, Scott's former owner had taken him from Missouri to Illinois, where he resided for 2 years before moving to Minnesota, then part of Louisiana Territory. In 1838, they returned to Missouri, and Scott was sold as a slave to Sanford. Although slavery was legal in Missouri, it was prohibited in Illinois by the state constitution and in the Louisiana Territory by the federal statute embodying the Missouri Compromise, the Act of March 6, 1820, third statute 545. Scott argued that these provisions made him a free man. In response, Sanford contended that if Scott were free, he was not a citizen of Missouri, and that the court therefore lacked jurisdiction over the diversity of citizenship provision of Article 3. Let me say it again. Missouri was a citizen of the government. And Scott was not. But I also have to ask and beg this question. Fuck the question they getting ready to ask. I got to ask the one I'm going to ask. If he took him to Illinois, okay, and then moved back to Missouri, and I hope I got that timeline right. If you wasn't a slave, why were you so, if he wasn't a slave, or should I say if he was a slave and then moved to Illinois where they didn't have a slave state, why are you still operating with the man? Were you really a slave? Or were you pretending to be a slave? Or were you using a narrative and not the end? Dead man tell no tale. So he can't answer this. Okay? But that causes me a little bit of pause. Okay? And was Scott always under the gun? Okay? Was he outnumbered in Illinois that he couldn't be free if he was in a free state? Why do you have to go back to Missouri? Was this a convenient ploy to keep the narrative in the area of public opinion? Because what's going to come out in here as we read is that is a blunder on the part of the courts. And it's a well-known blunder, whereas other people will say this has never been overturned. So it's still a blunder. Okay, let's go. That's just some questions I have. Because we are talking about Louisiana territory as I look at the page. But anyway, let's go. Um, Scott argued that these provisions made him a free man. In response, Sanford continued that even if Scott were free, he was not a citizen of Missouri, and that the court therefore lacked jurisdiction under the diversity of citizenship provision of Article 3. Moreover, mhm, moreover, where the hell did the word go? Oh, moreover, my finger was on it. Scott was not free since his presence in Illinois and the Louisiana Territory could not deprive his former owner of his property interest in Scott when he returned to Missouri. Okay, y'all see this delicate balance without the emotionalism. See this delicate balance. This balance, and when I say this, uh, don't take this wrong. Okay, but the delicate balance is saying something like, I rode into your town on a horse. Okay, and because I came into your town, now you have a right to take my horse, and I have no recompense in law. Now, I'm not saying that Scott is a horse, okay? I'm just addressing the property issue of it, which, as far as his human condition, has to do with a contracted position, okay? Let's continue. The court first addressed the question whether Scott was a citizen of Missouri for diversity purposes. The words people of the United States and citizens are synonymous terms and mean the same thing. They both describe the political body who, according to our Republican institutions, form the sovereignty and who hold the power and conduct the government through their representatives. Representative government, 3/5 clause. Don't forget that. Okay. Um, where to go? Representatives. They are what we familiarly call the sovereign people, and every citizen is one of this people and is a constituent member of this sovereignty, the states. Okay. Anyway, the question before us is whether a class of persons described in a plea in abatement compose a portion of this people and are constituent members of this sovereignty. Okay, I'm gonna read that again for certain people out here who may want to take that statement and run with it. The question before us is whether a class of persons described in the plea in abatement compose a portion of this people and are constituent members of this sovereignty. Where did it say anything about color? Okay. And what is the plea in abatement? There goes something for your Black's Law. Okay. Let's continue. We think they are not, and that they are not included, and were not intended to be included under the word citizens in the Constitution. I can therefore claim none of the rights and can therefore claim none of the rights and privileges which that instrument provides for and secures to the citizens of the United States. Remember, the citizens of the United States, they're talking about a union of the states. The people are secondary, okay? And think about it in the way that we've been raised to think we're second class citizens. A lot of motherfuckers are second class citizens, okay? Not based on color, only perceived as based on color, okay? And I know some people can argue that point because a lot of people have thrown a lot of stuff out here. But this is a new take on what we didn't see before because I ain't never been in slavery like that. But let's continue. On the contrary, they were at that time considered as a subordinate and inferior class of beings who had been subjugated by the authority and had no rights or privileges but such as those who held the power and the government might choose to grant them. Okay? And this is where we have to look at a newly formed government coming into play, a newly formed organization coming into play. Okay, think about it in the aspect of you creating an organization and then people, all kinds of people run the fuck in there and say they gonna roughshod over your shit. Okay, they're trying to form this through the slow legal process and the political atmosphere of the time. Okay, and if it's an old thing that one of my friends told me about the art of war. Some of us think we got to go head to head with everybody. Okay, you're gonna be so tired. You're gonna be like a one-legged man running a three-legged race. Sometimes in the art of war, you have to get your enemy to fight your battle. Okay, it's an old saying that I used to use. I ain't got to be fast. I just got to be faster than you. Okay, scapegoat mentality when dealing with the public. General populace dealing with the public, it's like the scapegoat mentality. What does a scapegoat do? The scapegoat leads the sheep. But when that scapegoat goes into that slaughterhouse, there is a door that that scapegoat can get out of. And the people, or should I say the sheep or goat coming behind them, don't know the difference. They go right to the slaughter. And this is what they were doing in public opinion, corralling the people, getting them into a frenzy, having them move because they ain't got to be fast. They just got to be faster than you. They ain't got to fight all the battles. They just got to get somebody to fight, okay? To believe what's been put down and do things that they themselves could never affect. They swayed popular opinion and people got on board because of herd mentality, okay? And they did it simply by saying black people are slaves. But now what are we finding out? That people of light hue from other places and other cultures were the first slaves. Okay? And just think about it. If your ancestors were one of those people in the South who took people that came from other places into their estates to do labor, and then somebody came along and said, oh, that contract's null and void. We're taking them people. They can do what the hell they want to do. You've been deprived of something. They call it property. We can call it labor. Okay, but it affects the economy, if you would. Okay, so I'm gonna stop right there because I think that's enough to kind of expound on that point. Let's continue. It is not the province of the court to decide upon the justice or injustice, the policy or impolicy of these laws. The decision of that question belonged to the political or lawmaking power. In those who formed the sovereignty and framed the Constitution, The duty of the court is, wait, let me stop there. Now, I'm going to read that last sentence again and give y'all a thought. The decision of that question belonged to the political or lawmaking power and those, semicolon, to those who formed the sovereignty and framed the Constitution. Okay? Let's see if I can pull my thought back. If you were on a ship and the cabin boy decided, we gonna create a union and throw these motherfuckers off, wouldn't you be a little upset? Wouldn't you be a little upset as the lawmaking branch and the framers who saw another entity in them three heads of government, legislative, judicial, and um, executive, that came along and said, or a lobbyist, if you would, agitator, whatever, that came along and said, fuck what they talking about. We getting ready to take this shit. Okay. When you be a little, that's kind of like mutiny, ain't it? Okay. You know, Wild Wild West type shit. Democracy type stuff, mob rule type stuff. Okay. How you gonna have mob rule if you don't have the people, the herd? Okay. You know, some folks, you can see pictures of some folks in a different sense. Uh, tying a wagon full of sticks and all other kind of what do you call it? Well, stuff that burns, setting it on fire and sending that bitch through the village. The horses running because their ass is about to get burned, and they just got slapped on the ass. But the result of that wagon that they've attached to this shit is equivalent to mutiny. Is that how the house got set on fire? Is that how Martin Luther King said, I sent my folks into a burning building? Okay. Because you can take the herd and direct it in a certain way. Because it is a herd. Okay. Let's continue. I don't see no dissenting voices in here. I guess y'all are really possibly enjoying this. Let's continue. Let me find my spot. Okay. Okay, remember the sovereignty. Okay. We think they are not. Okay, let's back up so we can put that in context. Okay. Let's start here. They both describe the political body who, according to our Republican institutions, form a sovereignty and who hold the power and conduct the government through their representatives. They are what we familiarly call the sovereign people, and every citizen is one of this people and a constituent member of this sovereignty. The question, therefore, is before us is whether the class of persons described in the plea and abatement compose a portion of this people and are constituent members of this sovereignty. We think they are not, and that they are not included and were not intended to be included under the word citizens in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides for and secures to citizens of the United States. Now, in here, let me make sure I see this correctly. Okay, no, I won't say that. But what I will say is that technically, none of us are citizens of the United States for the simple fact that it's a representative government, 10 miles square, that was created by some folks in the Constitution. So while they try to say that black folks wasn't included, neither were the white ones. Because as I said in Smoke's chat, I mean, not Smoke's chat, Bab's chat, let me take y'all back over there. Y'all might see it, but I'll scroll up to see if you really can see it. And this came earlier in the conversation before Bacon's comment. Right here, at 2:55. Okay, I can't bring it over anything, but at 2:55 and 4 seconds, Navi poet. Second question, because my first question was, so freedom of religion has or does not have standing based on their conversation? And then my second question would be, why would they need to declare this a white Christian nation? If the whites were already included, why would they have to declare it a white Christian nation? Hmm? And what about the more Muslim, one of them Muslim treaties? What is it, Tripoli or something like that? That the Constitution is supposed to also be in conjunction with? Why would they say that we don't find any Moorish nation, or I'm sorry, Muslim nation that's uh, against them or something? I can't quote it right now. It's in the back of my head. Okay, why would they have to declare those things? And I think Obama was the one that was the president that expounded on that when he was in office about the treaty. I think it was Tripoli's treaty, and quoting what they said about the you know Muslims, if you would. Why would people have to say that they were declaring this a white, white Christian nation? One, if we were guaranteed freedom of religion, and two, if blacks weren't included. I'm going to say that none of them were included. White, black, Mexican, brown, yellow, whatever. They weren't included. They were only able to do business with, going back to Section 8, Clause 2 or 3, however they're putting that up there, to regulate commerce with foreign nations and among the several states and with the Indian tribes. I think you're no longer a slave when you can do business with the government. Okay. Um, let's get back over here with you guys. Okay. Y'all still quiet. Okay. Um, so it says, da, 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 da. On the contrary, they were at that time considered as a subordinate and inferior class of beings who had been subjugated to the dominant race, and whether um, emancipated or not, yet remained subject to their authority and had no rights or privileges but such as those who held the power and the government might choose to grant them. Okay? It might not sound good, but it's right. It's right. Okay? It's right if you're not coming from a beggar victim mentality. It's right. Okay? But they're not going to tell you that. They're going to run the 1619 project straight up your ass. Okay? Oh, okay. Let's see here. I got it. Okay. Okay. Um, it is not the province of the court to decide upon the justice or injustice, the policy or impolicy of these laws. The decision of that question belonged to the political or lawmaking power, to those who formed the sovereignty and framed the Constitution. The duty of the court is to interpret the instrument they have framed with the best lights we can obtain on the subject and to administer it as we find it, according to its true intent and meaning when it was adopted. In discussing this question, we must not confound the rights of citizenship which a state may confer within its own limits, and the rights of citizenship as a member of the Union. Y'all see that? Okay. The Constitution has conferred on Congress the right to establish a uniform rule of naturalization, and the right is evidently exclusive and has always been held by the court to be so. Okay, that's a whole nother arena for finding out shit. To find out what that exclusivity is really all about. Okay, because even looking at trucking as a new entrant in trucking, there's some exclusivity that goes on here. Okay, I'll show y'all one. For those of you, y'all been running around here talking about LLCs for the longest, right? Well, I have yet to hear anybody tell the truth about, and well, at least in California, I don't know about other states, but in California, when you start your LLC, damn, somebody doodled a nice picture on this book too. Um, in California, when you start up your LLC, you have to declare what your stuff is made of, how many members, okay, its area operation, you know, all kind of criteria that comes into place. And as the LLC, it's only me, one, uno, one, okay. But in order to bring anybody else in on an executive level, I have to, um, what do they call it? Restructure my whole organization, my whole company, if you would. So it's not just a matter of, hey, I don't know, you got this expertise, and I want to bring you in, and you know, you can help me on this level, you know, with certain things that I can't do, or I don't want to do, or whatever the case is. Can't do it because the whole structure of it would have to be changed to adhere to the legal part of it, the lawful part of it. Okay, some of us don't want to do that. We want to say we scholars without going to school, and that's a reach because you don't necessarily need a degree, but you do need competency in certain areas. You know, give you another example. It's like California and Illinois. California, you're not dealing with probate like you have to deal with probate in Illinois and in Georgia. Okay? No matter how much I don't want to deal with that shit, I got to deal with that shit based on some things that just happened. But a lot of us will sit up here and go, just because we want it to happen means it can happen. You know, it can be done. We can violate this, that, and the other and get it done. And we have to realize that some of that stuff is just emotional wantonness. Okay? You know, like one brother said, and the biblical text said, you've been weighed in the balance and found wanting. Okay? But on the other end, you want to say that we're a nation of laws. Is it law or is it justice? Okay? You say, you can't tell me what to do. I'm a man. You can't tell me what to do. I'm a melanated. You can't tell me what to do. I'm Indian. Okay. Okay. There's consequences to every action. Okay. Sooner people realize it, sooner they'll be able to move on or be totally stopped in their tracks. Because some of this stuff that we're doing or has been done that the law don't apply to you because you weren't included in this state sovereignty and government thing, foreign or domestic, is the reason why you got scammers running around here trying to copy every fucking thing you doing. But people don't believe that we the ones in control. Negligent control. Okay? Anyway, let's continue. Let me find my spot. So here you see that they mention naturalization in here. So this is how we get to this point. Let's do it again. In discussing this question, we must not confound the right of citizenship, which a state may confer within its own limits, and the rights of citizens as a member of the Union. The Constitution has conferred on Congress the right to establish a uniform rule of naturalization, and this right is evidently exclusive and has always been held by this court to be so. Subsequently, no state since the adoption of the Constitution, can, by naturalizing an alien, invest him with rights and privileges secured to a citizen of a state under the federal government, although so far as the state alone was concerned, he would undoubtedly be entitled to the rights of a citizen and be clothed with all the rights and immunities which the Constitution and laws of the state attach to that character. This was very telling, confusing, but telling. It was telling because when it started to talk, when it said here, can by naturalizing an alien invest him with the rights and privileges secured to a citizen of a state under the federal government, I started to see the split between foreign and domestic. Okay. When it comes to domestic, we are what we are. First, okay? First nation, first people, first government, first body, first political body. We first. But because the foreign, or should I say the federal government, are dealing with commerce and international law, this allows other people who are not of this landmass to come in and get those rights. And as long as we sit on our laurels thinking about how much of a fucking victim we are, excuse my language, and what they did to us under Jim Crow, and who's light, bright, almost white, or as it said in the stream, who passed the paper bag test, is going to be a direct reflection on how much those people coming from other places get in them seats and make decisions before you, because some of them are willing to do what is necessary to be a part of one of the longest standing republics, or I don't know if I'm saying that right, newly formed governments, longest running constitution, yada yada. Okay. And this is where the problem comes in, because now we start fighting with foreigners for a seat that we already had. Okay. Had people not played the colorism game before. You guys should have seen 15, 20, 20, 20 some years ago or something like that, the little link where it shows us running a race, where it shows people on a track running a race. And on one side, you got people with no obstacles in the way, and then you got so-called our people being thrown all kinds of obstacles. Barbed wire, hurdles, elephants, whatever it is they threw on the field that we have to go through. Okay. But if anybody's able to understand that above anybody else, it should be the original people of this land on how to get around them things. Okay. They tell us run the race that's set before you. Sorry, I got to go into this. Now, I know there's another definition sitting out here for this, okay, which is not in my Rolodex, if you would. But race, ras, raza, okay, as I said before, that RAS is included in the word harassment. Okay. In many aspects, they had to slow us down. They had to slow our ancestors down. The people of the South, as far as I know, the economics of the South was trumping that of the North and the free states. So they had to throw obstacles out here, because if they didn't, we would have taken it all over anyway. Especially when you talk about we're the ones that gave it to them, because it was adopted from the Aboriginal people or the indigenous people of this land. So they had to throw obstacles out here. Okay. And the funny thing is that we will sit here and go, it's more than one way to skin a cat, and then lay down and start purring or scratching on something instead of doing what needs to be done. I'm just going to say it this way, and it's for comedic purposes only. Y'all know America is the home of the American cougar, right? I'm just saying, we should know how to move. Y'all talk about being Panthers, but y'all lying to yourselves. I'm just saying, put it together how you need to put it together. All right, let's continue. In the opinion of the court, the legislation and histories of the times and language used in the Declaration of Independence show that neither the class of persons who had been imported as slaves nor their descendants, whether they had become free or not, were then acknowledged as part of the people, nor intended to be included in the general words used in that memorable instrument. It is difficult to this day to realize the state of public opinion in relation to that unfortunate race, which prevailed in the civilized and enlightened portions of the world at the time of the Declaration of Independence and when the Constitution of the United States was formed and adopted. They just told y'all were knowledgeable. They just told y'all was intelligent. They just told you had a civilization. Okay, what they told you is that they had to hold you back from getting up in here and running this because they were trying to start something based on commerce. They didn't tell you about commerce part, but based on commerce. Okay. And the fact of, at some point you got to throw off them yokes. Okay. Sometimes you just got to throw it. I ain't mad at them. Okay. They's mad at King George. I wasn't mad at King George. Okay. I'm just saying, because of course I wasn't around then, but I'm just saying. Um, and here it says those who were imported. Now there's two importations. Okay. There's the importation of foreigners who were in other lands and decided to bring their ass over here, like the Act of 1682. Wait, 1682 and the reverse of 1862. Okay. And then there are those who got caught up in the fray because it didn't happen in a vacuum. Okay. And these people were in close proximity to people who were already here. And if y'all both got the same damn skin color or the same language or, same gender or work in the same profession, it's easy to give you a happy little suggestion one way or another or confuse the two groups as being the same thing, which could have caused a lot of people to say, well, I was going to say something else. Well, the hell with it. Charge all of them. Okay. If they act like blah, 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 then they are blah, blah, blah. If it walks like a duck, quacks like a duck, swims like a duck, whatever, it's a duck. Okay. And this is part of what's happened. We got mixed and mingled in some bullshit. Okay. Um, so I don't see this as that overall victim mentality for one major reason. None of us were born in that time. We may have some family members who have some gleanings toward what happened with Jim Crow. They may be that old, okay? We may have some stories from some of our elders because we're not that old. But for most of us, and I'm not the oldest around here, but I'm pretty close to the ones that I hear. I'm in that group. We ain't been in slavery, okay? We just have stories about slavery, discussions about slavery, and who was a slave. But we ain't slaves. None of us been slaves, okay? What'd you say? Limited liability company, Shelf Corp. All right, Focus Mind, I see you. Yeah, and that's the conversation too. Them shell corps, shell companies. Yeah, okay. Because some are really shells, and some of them are actually operating the way that they need to be, even though it's a certain protocol that has to be set up when you're setting up business. Okay. Because it's a whole bunch of folks out here talking about set you up an LLC, but y'all ain't doing no work. You ain't doing no business. You ain't got no income, and y'all waited, not y'all, but whoever it applies to, ran for them PPP loans and fucked around and found out. Okay, let's continue. But the public history of every European nation displays it in a manner too plain to be mistaken. Hey, OMAC, page number 503. They had more than a century before regarded, I'm sorry, they had for more than a century before been regarded as beings of an inferior order, and although unfit to associate with the white race, either in social or political relations, and so far inferior that they had no rights which the white man was bound to respect. I know y'all heard that before. And that the Negro, this is the only place they're mentioning color right here. I'm sorry, my bad. Um, and the Negro might justify and lawfully be reduced to slavery for his benefit. For whose benefit? Okay, you know, let me stop because my mind is working. Okay, if I don't know what the hell I'm doing because I don't understand what's going on and how it operates, I'd rather be a company driver than an owner operator. Okay, just to put it in the aspect of trucking. Okay, um, there's another point in here. See if I can pull it back from what I was thinking a second ago. What did it say here? So far inferior that they had no rights, blah, blah, blah. The Negro might justifiably and be reduced to slavery for its benefit. No. Oh, here it is. Okay, let me get this one. Watch this. They had for more than a century before been regarded as beings of an inferior race, and although unfit to associate with the white race, either in social or political relations. Just that part right there. I want y'all to remember what we read from Washington Irving when he talked about, hold on, I got the book right here. In our last reading, when he talked about um, the literate, the people who were writing stuff down. Let me see if I can find this real quick. Okay, not that one. Hold on. Okay, because what did they mention? They said, but the public history of every European nation displays it in a manner too plain to be mistaken. They had for more than a century before been regarded as beings of an inferior order and altogether unfit to associate with the white race, either in social or political relations. So keep that in mind. I'm gonna find this point from Washington Irving. It's in what the last part that we read, which I didn't title in the I didn't put it in the title. We just read about it from Washington Irving's book, page number 97, under the subject of English writers in America. Let me see if I can find the part. Okay. Second paragraph. I'm not going to go too high in this, but just this part right here. English travelers are the best and worst in the world. Where no motive of pride and interest intervene, none can equal them for profound and philosophical views of society or faithful and geographic descriptions of external objects. But when either the interest or reputation of their own country comes in collision with that of another, they go to the opposite extreme and forget their usual probity and candor in the indulgence of splenetic remark and illiberal spirit of ridicule. Hence, their travels are more honest and accurate the more remote the country described. I would place implicit confidence in an Englishman's description of the regions beyond the cataracts of the Nile, of unknown islands in the Yellow Sea, and of of the interior of India, or of any other track which other travelers might be apt to picture out with the illusions of their fancy. But I would cautiously receive his account of his immediate neighbors and of those nations with which he is in habits of most frequent intercourse. However, I might be disposed to trust his probity. I dare not trust his prejudices. Okay. Um, Let me go one more paragraph, and it might come into point, total clarity. It says it has also been a peculiar lot of our country to be visited by the worst kind of English travelers. While men of philosophical spirit and cultivated minds have been sent from England to ransack the poles, to penetrate the deserts, to study the manners and customs of barbarous nations with which with which she can have no permanent intercourse of profit or pleasure, it has been left to the broken down tradesman, the scheming adventurer, the wandering mechanic, the Manchester and Birmingham agent to be her oracles respecting America. From such sources, she is content to receive her information respecting a country in a singular state of moral and physical development, a country in which one of the greatest political experiments in the history of the world is now performing, and which presents the most profound and monumentous studies to the statesman and the philosopher. It didn't become altogether clear because I probably had to read a couple more paragraphs. But basically, in this part, when we read it, you can go back to my last post and hear me reading it, or the post before that and hear me reading it. It basically is saying that the more remote the place is, they gonna tell you all the beautiful shit because they took the time to measure all that shit out, like the pyramids and shit like that. Okay, to dig through bones and examine the bones. You know, it didn't mention that, but it's the same thing. But yet, when they got up close to the folks, okay, now they want to let their prejudices roll through. So when you start to hear this, where it says they had for more than a century before been regarded as beings of an inferior order and altogether unfit to associate with the white race, either in the social or political regions or relations, and so far inferior that they have no rights which the white man is bound to respect, and that the Negro might justly and lawfully be reduced to slavery for his benefit. Okay, this is where this comes into play at. Okay, mind you, Washington Irving is speaking in the same time that Dred Scott is going on. Okay, so would that qualify as the first source? What you say, DJ? The Order of the Black Swan can refer to two distinct things: a short-lived chivalric order founded in 1350 by Amadeus VI of Savoy, or a series of novels by Victoria Dannon. Hmm? That word. I know what right white race, right? Okay. Let's continue. Let's continue. Slavery for his benefit. He was bought and sold and treated as an ordinary article of merchandise and traffic, whenever a profit could be made by it. This opinion was at that time fixed and universal in the civilized portion of the white race. It was regarded as an axiom in morals as well as in politics, which no one thought of disputing or supposed to be open to dispute. And men in every grade and position in society daily and habitually acted upon it in their private pursuits, as well as in matters of public concern, without doubting for a moment the correctness of this opinion. Upon a full and careful consideration of the subject, the court is of opinion that upon the facts stated in the plea in abatement, Dred Scott was not a citizen of Missouri within the meaning of the Constitution of the United States, and not entitled to such to sue in its courts, and subsequently that the circuit court had no jurisdiction of the case, and that the judgment of the plea in abatement is erroneous. And I know some people just reduce that to a legal term like plaintiff in error. Um, y'all just made me think about the other statement that I put in that chat. which was by Bacon, um, which also kind of speaks on this. And I know some people like, I don't know about Bacon. I don't know about him either. Okay. But it was something that I put in the chat that Bacon had to say, because he's got several essays, and I'm not sure of his dates. But I want to read you guys something, if I can remember which section it falls under. Okay. Hey, I see them numbers going back up. But I put this in the chat. Like I said, I was over there in the chat damn near by myself. And mind you, some people get blocked because I just don't want to have what they're saying in my mentality, have to ponder it so frequently and often. So, um, damn, which essay was that? Check this one out. It was on plantations. Okay. DJ, sometimes I really think that Bacon basically took uh, his mama's stuff after she passed away, because she used to be a tutor to the royals. But anyway, listen to this, you guys. Y'all might find this interesting, something that people haven't spoken about. This is from the book I told y'all about, Major British Writers, um, where it had all the different authors in it, and Bacon being one. This is on page number 340 and 341. We're not going to read it all, but I want y'all to hear this, okay? This is his essay number 13. This is Bacon's essay number 13 of Plantations. Plantation means a settlement or colony in a new country. Bacon was personally interested in colonization, and after the failure of Sir Walter Raleigh's Virginian Company, he was one of the new adventurers, along with his cousin, the Earl of Salisbury, Captain John Smith, and others, in the London or South Virginia Company, chartered by King James II in 1606. Now, mind you, in that conversation they was having with Darvis up there, Darvis started to mention the Virginia Company in 1606, and that's why I read this or put this into the chat. But I couldn't put it all in there. I just lost my interest in there. But listen to this. Plantations are amongst ancient, primitive, and heroic works. When the world was young, it begat more children, but now it is old, it begets fewer. For I may justly account new plantations to be the children of former kingdoms. I like a plantation in pure soil, that is, where people are not displanted to the end to plant in others, for else it is rather an extirpation than a plantation. Planting of countries is like planting of woods, for you must make account. Well, I'm sorry. For you must make account to lose almost 20 years' profit and expect your recompense in the end. For the principal thing that hath been the destruction of most plantations hath been the base and hasty drawing of profit in the first years. It is true, speedy profit is not to be neglected, as far as may stand with the good of the plantation, but no further. Okay, here it is. Here it comes. It is a shameful and unblessed thing to take the scum of people and wicked condemned men to be the people with whom you plant. And not only so, but it spoileth the plantation, for they will ever live like rogues and not fall to work, but be lazy and do mischief and send victuals and be quickly wearied and then certify over their country to the discredit of the plantation. The people wherewith you plant ought to be gardeners, plowmen, laborers, smiths, carpenters, joiners, fishermen, fowlers, with some few apothecaries, surgeons, cooks, and bakers. In the country of plantation, First, look about what kind of victual the country yields of itself to hand, as chestnuts, walnuts, pineapples, olives, dates, plums, cherries, wild honey, and the like, and make use of them. Then consider what victual or esculent things there are, which grow speedily and within the year, as parsnips, carrots, turnips, onions, radish, artichokes of Jerusalem, maize, and the like. For wheat, barley, oats, they ask too much labor, but with peas and beans you may begin, both because they ask less labor and because they serve for meat as well as bread. And then it goes into some, I'm not going to read the rest of this because, yeah. Um, but I put part of that in. What I put in the chat was this part about it is shameful and unblessed thing to take the scum of people and wicked condemned men to be the people with whom you plant. And not only so, but it spoileth the plantation, for they will ever live like rogues and not fail to and not fall to work, but be lazy and do mischief and send victuals and be quickly wearied and then certify over the plantation to the discredit of over their country, over to their country to the discredit of the plantation. That's the part that was in the book that I was trying to allude to earlier. Okay. They planted the scum. They planted ex-prisoners, to a certain extent. Not everybody, because some people was, a lot of shit was going on. We like to pigeonhole the conversation, but I thought that was very interesting what Bacon had to say about plantations. Okay. Um, so let's continue. Okay. So last sentence to bring it back to our memory. Let's find the period. Okay, last paragraph because it's a whole damn paragraph. Upon a full and careful consideration of the subject, the court is of opinion that upon the facts stated in the plea and abatement, Dred Scott was not a citizen of Missouri within the meaning of the Constitution of the United States and not entitled to as such to sue in its courts, and subsequently that the circuit court had no jurisdiction in the case and that the judgment on the plea and abatement is erroneous. Okay. Let's get into it. It's gonna come out in here. I don't know how far it's gonna be. All right. Number two. That was number one. Here's number two. The court then discussed whether Scott remained a slave after his sojourn in the Louisiana Territory and Illinois. The act of Congress upon which the plaintiff relies declares that slavery and involuntary servitude, except as a punishment for crime, shall be forever prohibited in all parts of the country, in all parts of the territory ceded by France. Let me read that again because this is where I put in BAP's chat that they were coming away from rule under France. Again, the act of Congress upon which the plaintiff relies declares that slavery and involuntary servitude, except as a punishment for crime, shall be forever prohibited in all parts of the territory ceded by France under the name of Louisiana, which lies north of the 36 degrees 32 minutes north longitude or latitude and not included within the limits of Missouri. And the difficulty which meets us at the threshold of this part of the inquiry is whether Congress was authorized to pass this law under any powers granted to it by the Constitution. For if the authority is not granted by that instrument, it is the duty of this court to declare it void and inoperable and incapable of conferring freedom upon the one who is held as a slave under the laws of any one of the states. You got to understand that this also is touching on the part that the United States can't grant any titles of marquis. Okay. But also notice this here that Dred Scott is happening in 1857. Well, when did they do the 14th, 13th, and 14th Amendment? And excuse me for getting those two mixed up. But where it talks about involuntary servitude, didn't that come after the Civil War and after Reconstruction? So are they in error when they say, hey, it's relying on this where it says declares that slavery and involuntary servitude can only be asserted for punishment of a crime? Is that new, or was that always there, just not exemplified the way that it should, supporting the fact that the Constitution, coming from the Bill of Rights and the treaties, was always a progressive document that they knew was weak and still had to be amended and certain things addressed as the country developed as well. Okay. Anyway, so it's like, oh, they're talking about that 14th Amendment didn't even exist. That didn't exist. So how did they could be talking about that? They could be talking about it if they were talking about it before, based on the conditions that existed that didn't make it into either legal cases or popular opinion, or your little neck of the woods. Okay, let's go further. Thank you, DJ. It says, where are we giving this man doing court with an operable? Okay, next part. The power of Congress over the person or property of a citizen could never be a mere discretionary power under our Constitution and form of government. The powers of the government and the rights and privileges of the citizen are regulated and plainly defined by the Constitution itself. I know we wanted to hear them say black, and we wanted to hear them say women, and we wanted them to hear them say Moors, and we wanted them to say Indian. That's why we gravitate to that one word, Indians not taxed. Did we miss the part about Indian tribes? Okay, never mind. My bad. Let's go back. An act of Congress which deprives a citizen of the United States of his liberty or property merely because he came himself or brought his property into a particular territory of the United States and who had committed no offense against the laws could hardly be dignified with the name of due process of law. Okay. The right of the property of a slave is distinctly and expressly affirmed in the Constitution. Wait, the right of property in a slave. Okay. The right to traffic in it, like the ordinary article of merchandise and property, was guaranteed to the citizens of the United States in every state that might desire it for 20 years. Not a lifetime, 20 years. And the government in express terms is pledged to protect it in all future time. If the slave escapes from his owner, this is done in plain words, too plain to be misunderstood. And no word can be found in the Constitution which gives Congress a greater power over slave property, or which entitles property of that kind to less protection than property of any other description. The only power conferred is the power coupled with the duty of guarding and protecting the owner in his right. Okay, in his rights. Okay. Um, Upon these considerations, and I'm not going to elaborate on that because I need to think about that a little bit more, but it says, upon these considerations, it is the opinion of the court that the act of Congress which prohibited a citizen from holding and owning property of this kind in the territory of the United States north of the line wherein mentioned is not warranted by the Constitution. Okay, and is therefore void, and that neither Dred Scott himself nor any of his family, which were made free by being carried into this territory, even if they had been carried there by the owner with the intention of becoming a permanent resident. Okay, a little confusing right there. I think I might need to read that one more time. Let me do that one more time. I'll start here. This is done in plain words, too plain to be misunderstood. And no word can be found in the Constitution which gives Congress a greater power over slave property, or which entitles property of that kind to less protection than property of any other description. The only power conferred is the power coupled with the duty of guarding and protecting the owner in his rights. Business. Upon these considerations, this It is the opinion of the court that the act of Congress which prohibited a citizen from holding and owning property of this kind in the territory of the United States north of the line therein mentioned is not warranted by the Constitution and is therefore void, and that neither Dred Scott himself nor any of his family were made free by carrying him into this territory. Let me stop right here. I could read the last sentence, but the thought, I don't want to miss the thought. So basically, they're saying this of the court's opinion that basically they couldn't decide on the point of slavery because the Constitution didn't give them right to do that. Okay. Neither for nor against. Okay. Because in some aspects, slavery was like religion. Didn't the Christian religion, didn't it say that, when we looked at the Christian religion, that they were condoning slavery? Didn't they say that, in Bessie and all of that other stuff, that they used the Bible to support this concept of your slaves obey your masters for a time? The time was coming, but you have to understand this ain't my focal point, or should I say, the government was saying this ain't my focal point. That's some stuff y'all got to work through the political and social arena and all of this other stuff until it gets to this point. Work that shit out. We just don't like that it didn't come immediately. I didn't want to use that word, but yeah, that part, DJ. Okay. I mean, think about it. You got some stuff you want done. You done made it over here to seek your fortune, this, that, and the other. You sanctioned by whatever means. You ain't bothering nobody. You just roll your ass over here. And then you decide, okay, I'm going to need to clear 50, 60, 160, 200, 500 acres, whatever, because I was granted some land by some dignitary or whatever, or satisfy some legal requirement to purchase this land or give collateral for this land. And now I'm going to bring these people over here and they can't do anything but work on this land because that's what they're contracted to, even if some of them was duped into coming. Okay. Um, and you bring them over here and the next thing they know, uh, 70% of them run off. You bankrupt. So why wouldn't the government protect the business owner? Okay. Or you agree. And mind you, when I'm talking about this shit, I'm kind of talking about my own in one aspect that my great 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 grandfather and great 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 grandfather, if I got those levels right, on both sides of my family, told the Rayville plantation go to hell because they were brought with the McDade brothers over a little further east in Louisiana. And they wouldn't work on it because maybe the conditions were wrong, but they weren't slaves. They were workers. They were part of a work party or whatever. Okay. Just using that for an example. I had to understand that in my own circles. What'd you say? You said most were made criminals for the profit. Yeah, yeah, that part. Okay. So your problem ain't with us being called Aborigines and American Indians. Your problem is with the people that sold your family out from over there. Yeah, that part. Like we say, abdication. What's the difference between abdicating the throne, going into exile, and then there's some nuances between the two because some people lost their title but still in power. Let's continue. I gotta remember where I was at. Okay, right here. Last sentence. Um, even if they had been carried there by the owner with the intention of becoming a permanent resident. Finally, the court addressed Scott's contention that he had been made free by his visit to Illinois, a free state. The court held that his status on his return to Missouri was to be determined by Missouri law rather than Illinois law, and that under that law, he remained a slave. Okay. My thought is you shouldn't have never went back. If that was the case, you shouldn't have never went back. Okay. But in some aspects, it looks like Plessy versus the board Plessy versus Ferguson and Brown versus the Board of Education. They were just looking for the right case to use. And it didn't work out so well. Okay, let's continue. I want y'all to hear this blunder um, that they make of Tammany or Tanny. Okay, so here the justices last sentence. Justices Wayne, Daniel, Campbell, Greer, Nelson, and Cantron each wrote separate concurring opinions. Justice McLean and Curtis dissented. So y'all might want to go look at the rest of the judges that wrote on this because we like putting Tanny up there. Okay. Okay, let's continue. So here's the note on Dred Scott and the power of judicial review. Okay, and then it'll go into the reconstruction and retreat. Okay, but listen to this. One, two. Okay, two with an ABC section. Okay, one. The meaning of Dred Scott. After Dred Scott, were free blacks in northern states citizens of those states for federal constitutional purposes. Short of amending the Constitution, was there anything that either those states or the federal government could do to make them citizens? If Scott and his owners had remained in Louisiana Territory, could Congress have prohibited the owners from holding Scott as a slave? Okay, the meaning of Dred Scott. Two, Chief Justice Taney's opinion and the problem of judicial review. It is frequently noted that the Supreme Court first asserted the power to invalidate acts of Congress in Marbury versus Madison. Less often mentioned is the fact that the court's second assertion of this power came 54 years later in Scott versus Sanford. Okay. What lesson does Dred Scott teach us about the power of judicial review? Let's go back to that context here. It is frequently noted that the Supreme Court first asserted the power to invalidate acts of Congress in Marbury versus Madison. So y'all might want to go look at that because Dred Scott has a history. Okay. So let's skip to A. I just want to read that again to put that why Madison, Marbury versus Madison was mentioned. Let's go to A. A, the court's decision is racist on its premise and morally obtuse in its result. Is it fair? Notice that Chief Justice Taney does not claim that blacks are a subordinate and inferior class of beings, but only that they were so viewed by the authors of the Constitution. It says C, 2, 2, the letter C, Warren, the Supreme Court in the United States History 303, 1922. It says, if they were so viewed, does that fact establish that the framers wished to exclude the free blacks from ever becoming citizens? Even if the framers' attitude towards black was ambiguous, can it be doubted that they viewed slaves as a form of property? Is the problem with Dred Scott that the court was too passive in rigidly saddling the country with outdated moral attitudes, or that it was too active in reading the contemporary moral attitudes of the justices into the constitutional text? B, and this is setting up for what it's going to say later. B, the court unnecessarily and unwisely reached out to decide an issue not properly presented. The first part of Chief Justice Taney's opinion held that Scott was not a citizen of Missouri and that the court below therefore lacked jurisdiction. Was it proper for the court to decide the question addressed in the second part of the opinion? Why was it necessary to determine Scott's status outside Missouri? Even if Scott was free when he lived outside Missouri, did the Constitution preclude Missouri from enslaving him when he returned? Did Chief Justice Taney have to read the diversity clause as establishing federal standards for state citizenship? Why wasn't it sufficient to hold that Scott, even if free, was not a citizen under Missouri law? Listen to that. Why wasn't it sufficient to hold that Scott, even if free, was not a citizen of Missouri under Missouri law? Okay. C. The court unwisely assumed that it could finally resolve a divisive political issue by taking it out of politics. Consider R. Burt, The Constitution in Conflict 193 from 1992. Let's read. Dred Scott inflamed Northern fears and emboldened Southern leaders to to escalate their demands for national legitimation of slavery. The court had already set this course in prig by shutting off all possible malicious inventions in the fu- in the fugitive um, in the fugitive slave rendition process. The court drove the abolitionist lawyers out of public institutions and into the streets. You understand what's going on? Okay? Because they couldn't get what they wanted in the courts, they came out into the streets and started trying to have a mutiny, which probably ended up in the fucking Civil War. But anyway, okay? A riot, that kind of stuff. But let's go. Okay? Um, the court gave them virtually no option but to join William Lord Garrison there, as he burned a copy of the Constitution, describing it as a compact with the devil, and proclaiming that only the destruction of the Union could abate the evils of slavery. Dred Scott continued the course. It drove each side to more desperate or provocative claims, which in turn increased the apparent need if public order were to be preserved. Hmm. First, let me start that over again because I kind of messed up. Dred Scott continued the course. It drove each side to more desperate and provocative claims, which in turn increased the apparent need, if public order was to be preserved, for some single sovereign authority to exert command over the warring parties. These inflated expectations, paradoxically enough, had led the court to issue blustering commands that only provoked heightened disobedience and ignited more violence. Okay. Modern constitutional doctrines are sometimes justified on the ground that they remove highly divisive questions from the political process. For example, the abortion decision and expansive readings of the First Amendment religion clause are sometimes defended on the ground that the underlying question is inappropriate for political resolution. What are the characteristics of such questions? Was the future and spread of slavery such a question? And, again, this is why I mentioned Roe v. Wade, because they said the abortion decisions, and we know that in our time has been overturned. We know that it was brought about on fraudulent, uh, suspect conditions. I'll put it like that. Um, and then when you talk about the first reading, expansive readings of the First Amendment religion clause, are sometimes defended on the ground that the underlying questions are inappropriate for political resolution. This is what I'll add to that. I'll add the fact that when we talk about our nationality, we're talking about a political body. And um, in part of the process of creating a political body with uh, big headed people, okay, they assume that you have to be under the same religious banner, which is why y'all have all this religious fever about whether we're Hebrew Israelites or Muslims or Moors or Cretans or Christians or even now adding the Buddhists to it. And like I've said before, you can't be a part because you don't believe like we do. Okay. And what they're saying here, um, underlying questions are inappropriate for political resolution. You can't resolve this on a political basis because it's an individual one. I have a right to believe what I believe, and that's guaranteed by the Constitution, or not to believe. Okay, as long as I ain't doing you no harm. And my opinion shouldn't do you no harm, just like your opinion shouldn't do me any harm. But when it comes to us getting together, it's very harmful because it stifles growth. Because you think that a woman popped out of a man's side and you ain't never seen it. I'm sorry. My bad. My Tourette's kicked in again. Okay. But yeah, just take that into consideration. The court had to, they kind of went outside the realm, if I'm catching this question right. Let's go further. This is D, section D. I didn't see section D, but this is D. D says the problem was not that the court attempted to impose a solution on the slavery problem, but that it attempted to impose the wrong solution. Oops. The decision failed to solve the problem, exacerbated sectional tensions, and ultimately helped cause the Civil War. Should Supreme Court decisions be judged by whether they work in this sense? Should justices consider whether their decisions will be accepted, whether they will produce wise social policy? Judged by this standard, is it clear that Dred Scott did not work? In the long run, the decision contributed to a war that brought about a fundamental realignment of political power and initiated a new stage in the struggle over racial equality. Yeah, more than likely, this is what led to your Black Christian codes and Jim Crow laws. Okay? Because some people knew this shit, some did not. Let's go into section 2. Section 2 is dealing with the Reconstruction and Retreat. And just to expound on what they're talking about, it wasn't that he made a decision one way or another, he made the wrong decision. Okay? And we're still here talking about this has never been overturned. But again, we look at Tanny, we don't look at the other justices, and we don't go back to evaluate this stuff because people like to keep us back there so that we won't see the progression that got us here. Um, Section 2, Reconstruction and Retreat. A central paradox in constitutional law is that in order to enforce limitations on governmental power, it is necessary to create governmental power. The constitutional provision may, by its terms, prohibit certain forms of governmental action. That limitation might be obeyed simply because actors in the system recognize a moral obligation not to transgress it. I almost said trespass, but transgress it. But if the prohibition is to be legally enforceable, then some other branch of government must be invested with the power to enforce it. The risk, of course, is that the power will be misused and will serve to undermine the very rights it was created to protect. Does it follow that the real choice for the framers of the Constitution is not between individual rights and government power, but between different distributions of government power, providing more or less effective enforcement of individual rights with more or less risk of abuse? Before the Civil War, there were few constitutional constraints on the power of state governments. Pay attention. Before the civil rights, there were few constitutional restraints or constraints on the power of state governments. Remember, this thing was about, even at this point, it's about enumeration. Okay. Who's going to have what representation in Congress? Okay. Even though we're years removed from the initial of the 1700s. Okay. Remember, Civil War, states' rights versus federal rights. Y'all thought it was about slavery. And we know it's about economics. Never mind. Okay. Although the first 8 amendments to the Constitution protected individual rights against federal intrusion, The Supreme Court held in 1833 that they did not limit state power. See Barron versus Mayor and City Council of Baltimore, 32 U.S. 7 PED 243, 1833. Chapter 6, Section C, uh, INFRA, period. I don't know if that's inferred or infragmented or whatever. I don't know what it is. INFRA, period. The failure of the framers to protect individual rights from state governments was a product of neither indifference nor oversight. It stemmed instead from the view that the most serious threat to individual liberty came from the federal government and that the states could be relied on to afford complete. Let me read that again because that's a quote. It stemmed instead from the view that the most serious threat to individual liberty came from the federal government and that the states could be relied on to, quote, afford complete security against invasions of the public liberty by the national authorities, end quote. The Federalist number 28, Hamilton, okay, it just sat there all by itself. Anyway, a federal Bill of Rights applicable to the states would have enhanced federal power at the expense of the states and thus increased the risk of federal domination. Okay? We're trying to make it color. It is not. That was a scapegoat to get this shit to pass and sway the opinion in one way or the other. Okay? Um, but here, and that the states could be relied on to, quote, afford complete security against invasions of the public liberty by the national authorities. So, in other words, it's saying that the states were protecting their rights, citizens, okay? Not the citizens of their state, but that the state is a citizen of this union that's being formed, but the state had the ultimate responsibility in protecting its own individual rights as a state, which fell downhill upon the citizens. I hope y'all understand what I'm saying. Um, because even let's look at it like this. Washington, D.C. is 10 miles square. So they say, okay? They push legislation in and out and, all kinds of stuff, okay? But at some level, that shit they be talking about in Washington don't even reach down here to talk to us, to deal with us sometimes. I mean, like right now, May 7th, I believe it is, every state has to be in compliance with the, what do you call this thing? The Real ID Act. Okay, that's federal. Okay, but in the process of this becoming a national law, okay, some states have been complying for the longest, some have not. Okay, so, you know, different jurisdictions, of course, different jurisdictions. I said that like that was something new. Different jurisdictions that we're talking about, but the states was like, hey, I'm protecting my shit, and whomever those states, were, um, and the problem as well. I mean, I see benefit in that because um, if it was a matter of you're forming a new institution and everybody trying to run in there and take shit and do shit and get stuff passed and pissed off because what they want to happen ain't happening one way or another. Okay, imagine all the people that if the states would have had just an I mean the federal government would have had just we get to do whatever we want to do. We would have been right back in a republic. I mean, not a republic, a monarchy, a dictatorship. That's what they were barring against. That's why you got so many people sitting over there doing shit now. That's why the lobbyists are sitting over there doing shit now. Okay? That's why we got the problems that we have because People were running over there trying to do shit, trying to circumvent the laws that were being set up, the establishment that was being set up, if you would. You might not like it, but trust me, if we didn't have it, you really ain't gonna like it. Because the weakest among you, survivors of the fittest, survival of the fittest, Darwinism, all that shit is gonna cause you problems. Because whereas, we think, oh, I'm not protected by the government, you really are. Okay, because it's the quiet ones sometimes you got to watch out for, because y'all gonna get shot. We gonna shoot the shit out of y'all. Okay, it's gonna be wild wild west around here on some bullshit. you know um I'm just saying, y'all gotta put some laws in place to protect the criminals any damn way. Okay, I'm just saying, let me stop. I go too far with that sometimes. Okay, but yeah, I can see that need for the constraint of the federal government. um the pros and cons of those things. Some people can't. And so they try to make new inroads and inlets into things that sometimes have not been thoroughly vetted. Okay. I mean, not thoroughly vetted to the point that they say we supposed to have our own government, but y'all ain't set one up. Let's continue. But here's one. Haven't set one up to the point that I think it's against the law for you to actually have a certain kind of compact or something like that. But yeah, never mind. Y'all figure that part out later. Let's read some more. Okay, fellows. Okay, a federal bill of rights applicable to the states would have enhanced federal power at the expense of the states and thus increased the risk of federal domination. By the close of the Civil War, it was clear that this strategy required some modification. The southern states could not be depended on to protect the rights of the newly freed slaves, and it could hardly be maintained that the main threat of those rights came it could hardly be maintained that the main threat of those rights came from the federal government. Under the pressure of this reality, a shift occurred. Instead of viewing the Constitution as a protection from federal power and the states as the bulwark against federal interference, at least some people came to see the constitutional rights as a basis for the assertion of federal power to protect individuals against state interference. Ooh wee. Okay. Let's continue. Here's the note, which is kind of lengthy, and I'm not sure. Did I write that? Yeah, I think I did write that. Okay. See how far we going from here. Oh, yeah, we're not going to go too much further because then I'm seeing the civil rights cases, and then I'm also seeing the Ku Klux Klan, which we could probably deal with another time. So I'm not sure if I'm going to go into the next note after this note. Uh, yeah. Okay. Okay. Hopefully we'll run into this other term before we get to this next note, and that term would be market participation doctrine. Okay, let's read the note. The work of the Reconstruction Congress. Now, mind you, just reading what I read here, I understood something different, and this is where a new take on it came in, because I was realizing this isn't about color. Yeah, they implemented it, they stuck it in there. Everything that I've said today, as far as you know, setting it up for the masses and public opinion, even to the point of saying that they pissed some folks off so much that they had to take it to the street, burn the Constitution, and this is the cause of the Civil War. Okay. But what did they say? The Civil War was an undeclared war, and then they didn't have a treaty afterwards. They just stopped fighting. I think some people knew what the hell was going on. There was some shit in the sugar. Okay, I'm just saying. Um, so I'm not sure if I read this next part, and I see the Enforcement Act, so I don't think I read this that next part here. I'm just trying to remember how I get to um, the part about um, market participation clause. But let's look at this a little bit. Okay, this part is new for me. Okay, so here it says the work of the Reconstruction Congress. The Reconstruction Congress laid the groundwork for the expansion of federal authority by enacting three constitutional amendments, each of which conferred additional substantive power on Congress. On December 31st, 1861, the 13th Amendment became part of the Constitution. The amendment ratified and extended President Lincoln's Emancipation Proclamation by prohibiting slavery and involuntary servitude throughout the United States. In addition, Section 2 of the amendment granted Congress the power to enforce this article by appropriate legislation. Remember, they said who was going to enforce the stuff, so now we put it in there and we give the enforcement power behind it. I think that's what I'm seeing here. Um, The formal eradication of slavery was inefficient to change the real status of Southern blacks. The bonds of slavery was quickly replaced by black codes in many Southern states. The Supreme Court subsequently described the effect of these provisions as follows. Only question I have is how do you address this, okay, in our time? How do you adequately address this? But let's go. Blacks were forbidden to appear in the towns in any other character than menial servants. They were required to reside on and cultivate the soil without the right to purchase or own it. Inability to do business. Okay. Um, they were excluded from many occupations of gain and were not permitted to give testimony in the courts of any case where a white man was a party. It was said that their lives were at the mercy of bad men, either because of the laws for their protection, either because the laws for their protection was insufficient or were not enforced. The slaughterhouse cases, and this is part of the note. Like I said, this part is new for me. I think I ran into the slaughterhouse cases before, but not um, in this direction. Just cherry picking some stuff. It says the slaughterhouse case is 83 U.S. 16 Wallace or whatever Wall Street. I don't know what it is. WALL 36 1837. Congress attempted to make the 13th Amendment effective against the challenge posed by the Black Codes through enactment of the Civil Rights Act of 1866. Passed over President Johnson's veto, the act declared passed over President Johnson's veto, the act declared that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, were citizens of the United States. They put you back in. Yeah, yeah. You want to be Indian, you want to be African American. Let's go. Let's go. Okay, let's go. First in line, first in time. First in time, first in line. Okay, let's go. That's what I see here. Subject foreign power excluded, da 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 da. Granted. Okay, where we at? Not taxed, were citizens of the United States. Such citizens were granted the same right to make and enforce contracts. Inability to do business. Think about it. Um, Such citizens were granted the same right to make and enforce contracts, sue, give evidence, acquire property, and to full and equal benefits of all laws and proceedings for the security of persons and property as in is enjoyed by white citizens, end quote. Moreover, all citizens were to be subject to like punishment, pains, and penalties, and to none other, and to none other, any law, statute, ordinance, regulation, or custom to the contrary notwithstanding. Even before the Civil Rights Bill was passed, doubt arose about Congress' power to enact such a law. Thus, on February 13th and 26, 1866, Congressman Bingham introduced the first version of what would become the 14th Amendment. It stated that the Congress shall have the power to make all laws which shall be necessary and proper to secure to the citizens of each state all privileges and immunities of citizens in the several states, and to all persons in the several states equal protection in the rights of life, liberty, and property. Congress, Globe, 39 Congress, first session, 813, 1034, 1866. On April 30th, 1866, after extensive debate, the Joint Committee on the Reconstruction reported a new proposal that provided that, quote, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, and property without due process of law, nor deny any person within its jurisdiction the equal protection of the laws, end quote. These substantive prohibitions were coupled with another grant of power to Congress to enforce them, quote, by appropriate legislation, end quote. The amendment was adopted by the House in this form. When the amendment reached the Senate, the first sentence of Section 1, making all persons born or naturalized in the United States and subject to the jurisdiction thereof, citizens of the United States and of the state wherein they reside, was added. Let's read that again. When the amendment reached the Senate, the first sentence of Section 1, making all persons born or naturalized in the United States and subject to the jurisdiction thereof citizens of the United States and of the state wherein they reside, was added. The amendment was ratified on July 28, 1868. 2 years later, on March 30th, 1870, Congress added the last of the Reconstruction Amendments, which prohibited both the United States and any state from denying or abridging the right to vote on account of race, color, or previous condition of servitude. The amendment granted Congress the power to enforce this provision by appropriate legislation. Invoking this new constitutional authority, the Reconstruction Congress enacted an extensive legislative program. In 1870, Congress reenacted the 1866 Civil Rights Act and added criminal penalties for deprivation of rights under the law. In the same year, Congress passed the Enforcement Act, um, which attached criminal penalties to interference with the right to vote and made it a felony to conspire to injure, oppress, threaten, or intimidate any citizen with the intent to prevent or hinder the free exercise of any right granted by the Constitution or laws of the United States. 1 year later, Congress enacted the Ku Klux Klan Act, which criminally punished conspiracies to deprive a class of persons of equal protection of the laws and created civil liability for state officials who deprive persons of federal rights under the color of state laws. Finally, in 1875, Congress enacted a sweeping political accommodation law requiring all inns, public conveyances, theaters, and other places of public amusement to admit all persons regardless of race, color, or previous condition of servitude. Did this flurry of legislative activity fundamentally alter the constitutional structure that existed before the Civil War? This question has two dimensions. First, how did the Reconstruction Congress alter the power balance between the federal and state governments? No doubt the Reconstruction Amendments were intended to provide a new source of federal power to protect the newly freed slaves. But were they also a more general rejection of the traditional theory that state governments would serve to protect individual liberties? Or was the federal government to intervene only inter, interstationally, interstitionally, interstitionally, interstitially? Okay, never heard that word before. Hold on a second. Y'all know I got to do it. That word kind of bothers me a little bit. Give me a second, family. Interstitially means uh, the meaning of interstitial is occurring in or being an interval or intervening space or segment of relating to or forming an interstice, interstice. Um, yeah, I don't want to know how to pronounce it in a sentence. Let's find another definition. Okay. Relating to spaces between cells, tissues, or organs in the body, relating to connective, probably tissue, a medical field. Hold on. I don't know why they didn't use, okay. Anyway, organs in the body. Okay. Okay. I'm sorry. I had to see what that was real briefly. My apology. Thank you, DJ. Okay. Okay. Um, okay. I don't want to go into civil rights. So let me finish this section and um, market participative market participation clause. I want to remember that because I do have to touch on that just briefly because that's what I think it was. Your right to contract, which is what was being denied. Okay. Let's go right here. This question has two dimensions. First, how did the Reconstruction Congress alter the power balance between the federal and state governments? No doubt the Reconstruction Amendments were intended to provide a new source of federal power to protect the newly freed slaves. But were they also a more general rejection of the traditional theory that state governments would serve to protect individual liberties? Or was the federal government to intervene only interstationally when the states were unwilling or unable to provide protection? Second, how did the amendments alter the balance of power between the judiciary and the political branches? As noted above, the primary impetus for passage of the 14th Amendment was the need to provide a basis for federal legislative action against the state. But was the amendment intended as well to be a basis for federal judicial power? And the next one would be judicial reaction, but I'm not going to go into that. What I want to go into, okay, my notes that I wrote in the margin. What I want to go into is that term, uh, market participative clause, because I think this is where it's resting at. Um, Even though they're having their little discussions and battles and this, that, and the other, using us as human fodder. Um, Participative. Oh my God, it's not in there. Market participative doctrine. Let me see if it's under doctrine. Because again, I think this is more along the rights of being able to contract with this commercial entity that has this constitution that's based in international law and, of course, diversity of citizenship. Um, Let me see. Doctrine. Nope. I don't see it in here. Where did it put that? I'm sorry, y'all. I didn't write the page down. But I mean, just for where we are right now, I hope you guys see this just a little bit different. That it's not about the colorism that they were making us to believe it was about. It was about who's going to run this government, who's going to be the governing authority. If the states were going to bow down to the federal government, which was the baby in all of this that was formed on that illustrious date, or if the slave narrative would ring true. Okay. Because even when they talked about Abraham Lincoln, we've heard that whatever he declared, it didn't affect us. Okay, that it was only about a group that fell under this um, slave plantation doctrine of the 13th Amendment back in the day and all that stuff. Okay, and not the natural people. Damn sure not the people that was up under Francis, Louisiana. I'm just saying, okay? Because even I have a book somewhere around here that talks about the fact that in Louisiana, uh, so-called black people, so-called melanin people, people of color, were not prohibited from speaking against so-called white folks. Matter of fact, the book that I was reading about it was talking about um, how we held a moral standard for certain things that were being done by foreigners that were light bright and classified as white. Okay, so um, this whole stream right here talking about the Naturalization Act, Dred Scott and the like is about the fact that we had a right to it before they said we didn't. So when I kind of understand, even if you guys don't fully comprehend, I understand now why why Noble Drew Ali is quoted as saying that the 14th Amendment was not necessary for our people because it was our shit in the beginning that they adopted, um, and then we had to fight for it. Everybody had to fight for it. Some people weren't trying to fight for it because they were trying to fight against it because they had something to gain. They had profits to be made. I mean, even there's a story about one brother coming over here from, I want to say it's the Isle of Man, where they use the word suzerain as opposed to sovereignty or suzerainty. Sorry about rolling whatever the fuck I just rolled, but suzerainty as opposed to sovereignty, where basically he wasted all of his shit and then came over here and tried to start some new shit. Okay, there were people who came over here to get away from their family over there and got called back home, and they said, I'm not going back over there to deal with them. Okay, and it was sink or swim for them over here. So they had a vested interest in by any means necessary to get things done, um profits or the like, to put themselves back in some kind of standing after um messing up their family inheritances over there. There's a lot of things in the midst here. I mean, we're looking at people who came over and during the Pitchfork Rebellion and the creation of certain places like Rochester and the like, and splits that happen between why some people with so-called, I would say, French sounding names go by different distinctions, where some might be in blaring colors where others went under the radar because they didn't want to be identified. um, it's a lot of nuances here. Okay, um, a lot of nuances that come into play here. And again, I think it falls in line with the ability to do business, the right to do business, to be protected in business, and not have people steal your sugar honey iced tea. Okay. Um, and not so much about colorism, even though we have to deal with proponents who gravitate to colorism, skin color, classism, the caste system. Um, Even how I was showing on that one stream or saying on the one stream, even if I didn't show people, that you can clearly see there's a definition for prejudice, and I believe that we are all prejudiced in as much as we prejudge. Okay, and anybody who's been to college should know that conversation because it's an official narrative. And then how they took the word prejudice. Like I said, we are all prejudiced because we prejudge, but we are not all races. And they took prejudice and they tied prejudice to classism and made them one and the same. It's some shit going on. It's some shit that's been going on, and we're still here playing in the shit. Okay, it's almost like when I went down south for the first time in you know as a teenager. Shit, I saw a body of water, what I thought was a body of water, and I was getting ready to go swimming because I like to swim. And when I went in the house and grandma and them asked me, "What you getting ready to do?" I said, "I'm getting ready to go swim in the pond." They said, "That's not a pond, that's a cesspool." We've been swimming in the cesspool, okay? And that has a lot to do with how instruction came through the official channels, the school, and popular opinion. But we have not been in them legislative halls. We have not been in them legal arenas to really look at this and assess this. We've been doing like we do on social media, bantering over our emotions and the things that we think and feel, as opposed to doing the real work of study, which were those people. The people who were really doing those studies, they were on a level. And a lot of us need to really get there. And it's tedious to sit up here and read one fucking definition out the dictionary, okay? Or talk about one discussion on hunter or gatherer and then watch people change the damn definition. But anyway, you know, that's not the way we're supposed to do this shit. Okay, we're supposed to be able to tie these languages back together, not have stupid ass conversations about what we think. It was even shown when Montegator brought that word addict, addicts in there, and it got tied to other spellings for addicts, and then it got tied to ads and um, ADDS and ADS, and then the other brother came in and said, "Hey, isn't there a Greek story about some person named Addicts who was the king of the woods and this, that, and the other?" Like I said, we have to learn the whole spectrum of it, not just the part that makes us feel good or makes us feel bad. Okay? When they make us feel bad, we start, it's almost like Sister Act, when Homegirl said, "Harpo, who this woman?" And the piano player said, "Time to go." Okay? It's almost like that. It's like, um, I forgot how I wanted to put that in there, but it's time to close up shop sometimes because people been having fun at your expense because you got the emotion to stay with the colorism, to stay with the victimhood, okay? And then you get mad when it don't work in your favor. And just like these folks who couldn't get the legislative thing to go the way that they wanted to go, now they're gonna take it to the streets. Now we need to set up a militia. Now we need to go have a war. Okay, now we need to burn down a city, all serving a purpose that does not benefit us because we were guided by popular opinion and frustrated ass people who couldn't get it the way they wanted it for the purposes that they wanted it. And in some aspects, just put it here for me. When I was growing up, we heard all the stuff about what happened in the South and in slavery, and we were slaves. Anybody that went to American school, and I can say everybody because I didn't go to everybody's school. I went to the schools that I went to and saw the blurb in the books. But because of those narratives, whether it's roots or whatever we read or whatever they put in the textbooks or however it went, even in the church. because we be equated to the Hebrew Israelites on some slavery shit all the damn time. Um, I didn't want to plant. Uh, I didn't want to plant shit. Okay, even though my family is from the South. Okay, I don't want to work the fields because that's for foreigners. That's for migrants. That's for slaves. Now we're of the opinion that you better plant your own food. You better grow your own shit. Okay. Yeah, that shit happened, or it may not have happened, and they just said it happened. Either way, you better take this bull by the horns. Okay. Or you gonna be like them people in that person in the Bible when they said they killed him between the horns and the altar. Okay. Because they got you in the middle road. Um, in the herd mentality, if you would. Um, I'm still looking for this damn text right here, and I just can't find the right term for it. And I might have to come back. I'm glad I didn't put it in the title, um, but I can't find the marketplace participation doctrine. Let me see if it's in this one. Participation. Ah, but again, this is why I put these things in the chat, that I thought that this was about the delicate balance between free states and um, slave states, and not about colorism. That an alien are the citizen, the people who are alien to um, the governmental body that is a citizen of the federal government. So many of us, not just how Indians not, black folks not, or Africans not, or white squatchulators not. None of us were citizens of that. Okay, but we are all supposed to be protected under that as it was intended to be, because we would have to find the contract that made us a slave and not just the skin color that they used to say that we were a slave. You can say what you want to. Okay. Um, we have different histories that we have to deal with and stuff like that. You don't get to put me in a fucking grab bag. Okay. All right. And I just wanted to push this a little bit further in the minds of the people, because it'll probably be a long time before a person has the ability to come up here and really talk about the Naturalization Act on a particular level and not use the colorism thing while doing so. Okay. Um, but you guys, if y'all got the fortitude, y'all can go back to Baps King of YouTube and listen to that post. Y'all see what it is, the name of it. You see about where I am in the stream of this conversation. Um, I'm just hoping that some people stop doing some fuck shit that they doing. Okay, because Darvis ran roughshod over that post. And like I said, is it justice? Is it law, or is it justice? You can say the law is whatever you want. You can say it's the black codes and Jim Crow laws, but is that justice? That ain't justice. And for those of you who, again, going back to the beginning of this stream, because I'm about to end this because I cannot find this thing. Um, if y'all haven't seen the movie The Beekeeper, go look at it. Apply that to other things that are going on. Shit, I got some real time stuff that goes right along with that. Matter of fact, I had to call Amazon today and talk to them about some things with an account and a purchase and all of this. And when I referenced that movie, he said, I know exactly what you were talking about. And this was a foreigner. Okay. You know, um, I ain't gonna tell you what Indian or Punjab or something like that, Punjabi, East Indian or something like that. But he understood exactly what I was talking about in the aspect of scamming. And I said, I'm not that one. Okay. I'm not that one that's going to do certain things and end up like that. But this is in our environment because we've made it easy for others to come in and do that because we won't do what's necessary for us to do. Okay. You ain't want that missile up your backside. You on some shit, DJ. Um, you know. But excuse me. But in that movie, he asked her the question near the end, or tells her, you're going to have to decide between law and justice. Okay? We know from religious areas, from the Bible, whatever, whatever, they say that nobody could keep the law. Okay? You can say what you want to, but is it justice? In this circle here from years past, especially the Moors, they talked about Hammurabi's code. But when you go and look at Hammurabi's code, that might be good for you if you swing it, if you got something swinging between your legs. But for the ones that didn't, that ain't justice. And if it ain't justice, it really can't be law. Okay? So take your delicate balance over there and let your pendulum swing. Okay? But we gonna split the narrative because that's our thing. Yeah, okay? I'm just saying. Hope y'all caught what I was saying. Okay? Um, just justice. It's about justice. And sometimes you just gotta draw that line and say it's either this or that. Okay? You can't say it's all this at one point and then when you're brought to the floor, Darvis, it becomes both because you don't want to commit because you trolling niggas. Okay? Can't keep insulting our intelligence on some bullshit. All right? So if I can find this participative clause, it may come back up in some of our future stuff. Marketplace participation, but to put it into your head again, I believe a citizen means that you have the ability to contract, okay? And not so much about they stole your rights because that was a person, that was a group, that was a ideology that was doing that shit. Again, that whole narrative, they stole my birthright. When I started to understand what y'all was talking about in relationship to this, even though I had heard some of it before from an ex, I went right to the book where it talks about Esau and Jacob, and y'all ain't fell off that shit yet because y'all need us to be that kind of person and understand those type of laws, even though you can't enforce the shit and you don't know where the God is that you claim exists, or create me a universe if you God. I'm just gonna say it, okay? I'm so tired of this damn God complex that folks have, okay? Um, But anyway, that's it for me, family. I've been up here for 4.5 hours. We going on 5 just to read some of this stuff. I wanted y'all to hear that. Okay. I wanted y'all to kind of slow down for a minute and see what this possibly was about. That it is not about colorism. They keep playing with y'all on colorism. You keep playing with yourself on colorism. I'm gonna need y'all to stop playing with yourselves on colorism. Okay. And stand on the high honors, the high intellect, the high considerations that our families, our people had, the high civilization that we had, and stop playing in the sewers of your life with these folks that are too lazy to read because, like Bacon said, it's the scum that you're trying to transplant into the plantations, if you would. And they're lazy and they discredit the plantation. Okay. So, family, let me get out of here. Peace to you guys. Bap, don't you strike my channel because I only played a little bit of your stuff, okay? But it is what it is. So, family, I hope you guys enjoyed this installment here, the Naturalization Act, Dred Scott, and a new take on it. Understand why that 13th Amendment ain't necessary because your rights were already protected, but you had to enforce it because there was no enforcement. So, peace, family. It's your girl Navi. I'm out. And I want to thank you guys all for showing up. Those of you who stayed, hit that like button if you would. I think we need 6 more people. Okay, go get your troll accounts. Give me my 6 people so that I can start some memberships and go private. You know, a little bit. Because when I get there to that 500, it's a lot of videos that I'm going to open up to make sure I satisfy YouTube's requirement. See if those will be accepted for me to go into the membership part of it. because everything ain't for everybody. Okay. And I'm still up in the air about this webinar um, for the trucking business. Like I talked to my sister, she said things changed because I asked her, "Have y'all done this? Did you do this? Did y'all have to do this when y'all started your trucking company?" And she said, "No, it was new back then. We didn't have all those particular regulations." But what I'm finding out right now is that I have to take a whole course in order to keep these scammers and opportunists off my back with this. So I'm thinking about doing a webinar to show that process without any of the specific things, like business numbers and names and, uh, you know, EINs, even though all of that is there. But for those who are interested, want to find out a little bit about trucking, I may end up doing a little webinar on that. Um, and stay tuned to my um, community tab for information on that. Okay. And we'll see how that goes. I don't know how it's going to go, but it's definitely a thought there, um, because it's a real interesting course. You know, like I said, I've gotten many phone calls right after stuff got established, and oh, I know I was targeted. I know I was targeted. And if I would have been fearful, if I would have been lazy, just trying to get it over and done with, I would have been a victim of something. But I'm choosing to study through it. When I questioned why something happened, I went to state representatives to find out about that thing and was directed to a place that allows me to see everybody coming in that arena before they even open their mouth. And I get to see how they do what they do. And I've held some people's feet to the fire and they had to readjust some shit because I ain't just a woman, a stupid, silly woman that don't know shit. So I might want to bring that to the table for some of us. So anyway, family, um, yeah, that part. Okay. So again, I appreciate each and every one of you that showed up. I'm not going to mention y'all by name. If y'all's in the chat, you see it. And if you was here, you know it. Okay. So peace, family. Y'all enjoy the rest of your day. I got to get ready because I got to get a head start on Monday morning when they blow my damn phone up. Okay. Okay, DJ. I got you. Peace, family. Let me get this outro in. Y'all have a good day. Hope y'all find something interesting around YouTube. Peace. And check out The Beekeeper. It's interesting. Now, how the hell do you stop this damn stream? Let's go here. Peace, fam.